they're under to the extent a conflict does exist. Given the waivers, the court will consent to hear the matter. Court does call the case of the people of the state of Michigan versus Stila
Cotton.
Ready, Judge. Torshell Feaster, Assistant Public Defender, on behalf of Mr. Cotton. Mr. Cotton, please state your name for the record.
Castilian Cotton.
All right, I have before me a plea form that indicates that he's going to be pleading guilty to the charge of use of a controlled substance, that being cocaine, the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor.
That is correct, Judge.
Mr. Cotton, can you raise your right hand, please, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, state your name again, please, sir.
Castilian Cotton.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of a controlled substance or use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that?
Yes, sir.
All right. And I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. Do you understand that, sir?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You had someone sign rights form on your behalf?
Yes, sir.
Do you have any questions regarding any of those rights?
No, sir.
You understand that you're waiving all of those rights?
Yes, sir.
Understand you're giving up your right to appeal of rights?
Yes, sir.
Are you on probation or parole? You are not, correct?
I'm doing time in Wayne County.
Gotcha. Has anybody promised you anything other than what's been stated here today to get you to plead guilty? Anybody threaten you or push you?
No, sir, Judge Simpson.
All right. You're doing this voluntarily and of your own free will?
Yes, sir.
All right. And also because you believe that you're guilty?
Yes, sir.
All right. I'm done with those questions now.
You know I'm not going to play with you.
Yes. That doesn't work out for people when they do, right?
Yeah, I ain't going to never play with you.
All right. Sir, on the date of August 25th, 2025, at the location of West Michigan Avenue near Ellsworth in Ypsilanti Township, Washtenaw County, State of Michigan, did you have cocaine in your possession?
Yes, sir.
Had you used it?
Yes, sir.
Did you know what you were using was cocaine?
Yes, sir.
All right. Sir, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, misconduct is defined under the Michigan court rules, that the court would no longer be bound by any sentence evaluation and you could not withdraw your plea. You understand that?
Yes, sir.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this?
They are.
It's all on the record, Judge.
All right. And have I complied with the court?
People are satisfied.
You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this case will be
25th at 10 a.m.
June 25th, 2026, 10 a.m. before Judge Washington.
Thank you, Judge.
Sir.
Bond will continue. Right. Good luck to you, Mr. Cotton.
Yeah, thank you, sir.
Court calls case of the people versus Anthony Holston.
Can we have the people? That's a miscarry I can run.
Oh boy.
Ready, Judge. Torshell Feaster, Assistant Public Defender, on behalf of the defendant.
All right, where's Princess? Oh, here she comes. All right, man, just checking.
Morning.
Assistant.
Welcome.
Thank you, Judge. It's good to be here. Assistant Public Defender Tanazi Carey-Action-Ruley on behalf of, I believe this is Anthony Holston.
Mr. Holston, can you state your name?
Anthony Holston.
Judge, we're asking for an adjournment. I think we've reached a resolution with the people. We just need to put the paperwork together and finalize it.
Need the paperwork together then?
Yes, Judge.
We're on the 7th. 28th. Because we've got to do a video, right? So I'll adjourn it to May 28th, 2026, 9 a.m. And hopefully at that time, Mr. Holst will be able to take care of your matter. Okay, sir?
Thank you, sir.
Thank you. Bond continues.
Thank you.
Judge.
Court calls the case People versus Sarah McCormick.
Right, it's over to the people here.
Sorry.
Soldiers are still.
So you want to state his counsel, state your appearance. Prompted him. I still have nothing. All right, Ms. McCormick, we'll call your case back up. We're just trying to get your counsel to finally answer. All right?
Okay.
Thank you. Court calls the case People versus Jazmine Morris.
Good morning, Your Honor. Assistant Public Defender Davi Lebo for Ms. Morris.
Ms. Morris?
Your Honor, Ms. Morris is presently at the Walter Reuther Hospital. I did speak with them yesterday.
She's present.
Morris, okay. Ms. Morris, can you state your name, please? Okay, that's Ms. Morris. Got it. Okay. I have a report indicating that she's incompetent to stand trial but restorable.
Yes, Your Honor. And I did speak to the Walter Reuther Hospital yesterday. They've indicated that they are still in
I'm ready
progress.
to
and
go
don't have it.
home.
All right, hold on, Ms. Morris.
I'm doing better.
Okay. I'm sure you'll get there. All right, is there any other additional evidence from either side?
No,
Your Honor.
Would ask that the court accept that report, be stipulated to a finding, and ask the court making finding of incompetent but restorable at this time.
No objection, Your Honor. And that is
Oh,
our
the Jews.
Based on a review of that report, I would find that the defendant is at this time incompetent to stand trial, but the treatment is restorable. Court will sign an order to that effect. I will set a review date for
13.
set a review date, August 13th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
All right, thank you. Court calls the case People versus Anthony Mullins.
People.
Morning, Your Honor. Civil Court David Burgess on behalf of Anthony Mullins, who's appearing via Zoom from the Michigan Department of Corrections.
Mr. Mullins, can you state your name, please?
Anthony Mullins.
Thank you. I have before me a plea form that indicates that he'll be pleading to an added count 2 of use of methamphetamine, then 1 year offense. Upon a successful plea to that, count 1 would be dismissed. They're agreeing to immediate sentencing.
If the court would do that, Your Honor, I think Mr. Mullins is currently in MDOC, and this is what's holding him up.
So that's accurate, Your Honor.
All right.
Mr. Mullins, we're entering the plea to the use today, sir.
And that's why I did not seek judge waiver part, Your Honor, on the plea form, since that's formal sentence.
Okay, but I got it. Yes. All right.
I think my client's ready to proceed.
All right. Mr. Mullins, can you raise your right hand, please, sir? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name again, please.
Anthony Mullins.
All right. You can put your hand. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You had someone execute an advice of rights on your behalf?
Yeah.
Do you have any question regarding any of those rights?
No, sir.
You understand that you're waiving all of those rights.
Yes, sir.
Understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, not the time.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Correct.
And also because you believe that you are indeed guilty?
Absolutely.
Okay. November 25th, 2024, at the location of 1701 East Michigan Avenue, Ypsilanti Township, Washtenaw County, State of Michigan. Did you have methamphetamine in your possession?
Yes, I did.
Had you used it?
Yes, sir. I was in the act.
Okay. And you knew what you were using was methamphetamine?
Yeah, for sure.
Thank you. Counsel, you're not aware of any other promises, threats, or other inducements which have led to this place?
Your Honor,
No, Your Honor.
And have I complied with the court?
people are satisfied.
You have, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Anything you or your attorney want to say before I do impose sentencing?
Your Honor, I would just indicate that he's been in custody for over a year, and also he's been trying to get himself back together. He's completed a rehab through the MDOC as well as attending regular NA meetings, Your Honor. So
Fines and costs of the state minimums of $125, although 365 days incarceration, credit for 365 days, sir.
Thank you, Your Honor.
thank you, Your Honor.
Thank you, sir. Good luck.
Thank you,
I'm
sir.
here on the McCormick case.
Lord.
So you just said it like. Really?
Well, yeah.
Like Zoom etiquette.
None of us are here, Judge Brown.
Court calls the case, People versus Sarah McCormick. Recall.
Good morning, Your Honor. Andrew Cito, P87447 on behalf of defendant Sarah McCormick.
We have her on.
I'm trying to force it. Here she is.
All right, Ms. McCormick, can you state your name, please? Oh. I don't have her.
She's unmuted.
I know she's unmuted, but I can't.
Sarah Lynn McCormick.
Thank you. All right, what are we doing on this case?
Judge, this is the first pre-trial hearing, and we are still negotiating in good faith regarding a plea deal and also working on more discovery. So we would just ask for a short-term adjournment.
Without objection, probable cause conference will be adjourned May 28th, 2026, 9 a.m. Bond continued.
you.
Thank you, Ms. McCormick. Court calls the
Thank
case,
you.
People versus Desawn Jones.
Your Honor, Raymond Cook for the people.
Edward Lucas for Desawn Jones. He's approaching.
Your name?
Jones.
Thank you.
Your Honor, I'm asking for an adjournment today. I'm asking for an adjournment.
28th work for you or you need?
Based on some of the mitigation, I'd ask for a little further. The 20,
Mitigation in or
we're working together on the mitigation.
on the mitigation? June 11th. 2026, 9 a.m. Bond continues. Court calls case, People versus Tanisha Moore.
Your Honor, Raymond Cook for the people.
Defender Secretary, I can really, Your Honor, on behalf of Ms. Tanisha Moore, who is coaching.
Good morning, Your Honor. Mark Page on behalf of Mr. Moore and file 1920. Standing in for attorney of record, Mr. William Amadeo.
Your name?
Tanisha Moore.
Thank you.
Your Honor, in my case, we would be asking for 1 week adjournment. I believe there's a global offer in the works, Your Honor, in this matter. And
There's
that's,
what? A global offer.
yeah, global offer.
That is my understanding too, Your Honor. I spoke with Mr. Cook, and he's gonna forward me the offer that was extended to Mr. Amadeo, and it does involve my case as well as some other misdemeanor matters.
So you'll have everything ready in a week?
That's my understanding for Mr. Amadeo.
I know, but Cook, do you believe that to be the case? Mr. Amadeo say anything to him? No.
Has been extended. I believe that it's likely to be accepted, so we just need to have that final conversation, draft up the plea.
Got it. Yes, okay, I'll adjourn it 1 week out. So I'll adjourn it to the 15th. No, I'm sorry,
I believe that'd be
21st,
21st. Thank you, Your Honor.
21st, 2026 night.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you.
Court calls case People versus Quinton McKenna.
Good morning, Your Honor. Marcia Cratchit on behalf of the Attorney of Record, Mr. William Amadeo.
Where is he?
I was up.
State your name.
Quinton McKenna.
Is he waiving?
Yes, Your Honor.
Sir, you're waiving your right to a preliminary examination? That was a question.
Mr. McKenna?
I'm sorry, you cut out.
Okay, are you waiving your right to a preliminary examination?
Yes, sir.
All right. Do you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
You understand that by waiving that proceeding, you'll not have that hearing of the circuit court for further resolution?
Sir.
Do you understand that, Mr. McKenna?
Yes, sir.
All right. People also waive their right?
Yes.
Preliminary examination having been waived, defendants bound over to circuit court on the single count.
As to the arraignment, Your Honor, we waive the formal reading, acknowledge receipt of the information, and ask the court to allow my client to stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 8th at 1:30 with Judge Conlon.
Conlon,
Yes.
July 8th, 2026, 1:30, Judge Conlon.
Thank you, Your Honor.
Bond continued. Thank you.
Sign information, Your Honor.
Yes, momentarily. Court calls case People versus Scott Zurich.
Your Honor, Raymond Cook. Please, in the side room, you know.
O-I-N.
John Shea, Your Honor, with and on behalf of Scott Zurich.
Your name, sir?
Scott Zurich.
All right. First of all, I guess the record should reflect we had an in-chambers conference prior to the docket beginning. All right. Where things were discussed, and where are we on this case?
Your Honor, I was drafting an order.
Got it.
I believe that after discussion with Mr. Cook and with Your Honor, the parties are agreeable to Mr. Zurich being released to mental health treatment pursuant to a probate court order entered 2 days ago. And of course, we can't predict how long that hospitalization would last, but on release, Mr. Zurich will reside at his sister's house. Her name is Emily, and her address is do you want that on the record?
I do not.
Okay.
But it's
I'll write in the order.
say that the agreement was he would not be residing in the city of Annam.
Correct.
All right.
That's right. And the court will have a review, the Thursday after he is released from inpatient treatment.
Yes, I've assured the people that we will, once we're notified of that, I will set it for a hearing a status hearing the next Thursday.
Your Honor, that's all my understanding. I don't know if it was mentioned, but just to make sure it's clear. My understanding is that once he's released from that treatment, he can go out and complain tether to that location. Staying there.
That's correct.
That will correct.
The order that I'm drafting.
That will be in that. And does he have a PCC date set currently?
Yes, I think
What
today, Judge.
Today?
Yes.
So I'll have to adjourn it out in any event. So what I'll do is I'll adjourn its probable cause conference out to June 4th. We'll just do 30 days out, 2026, 9 a.m.
Very good.
And I will sign the order regarding his release. So just at this time, I'll indicate that his bond continues. And then once I receive the order, I'll sign off.
Thank you, Judge.
All right. Thank you.
I will have that to you yet this morning.
All right.
All right.
Thank you, folks. Thank you. Should have an issue or? Was that the? Oh, that may have been the victim in the case. Court calls the case People versus Justin Chavez. An AG.
Morning, Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Good morning.
Morning, Ms. Williams.
And good morning again, Your Honor. Assistant Public Defender Davy before Mr. Chavis.
All right, Mr. Chavis, state your name, please.
Yes, Justin Chavis. Good morning, Your Honor.
Good morning. All right, what are we doing?
Your Honor, Mr. Chavis will be waiving. I'm just going to ask his permission to sign the waiver form on his behalf at the podium, please. Mr. Chavis, do I have your permission to sign that as we discussed?
Yes, sir.
All right. You're waiving your right to a preliminary examination, sir?
Yes, sir.
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over circuit court on both counts.
Your Honor, we acknowledge received information. We waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 15th at 1:30.
July 13th, 2026, 1:30, Judge Hamud.
Thank you, Your Honor.
Bond will continue. Thank you.
Yeah.
Is that it for G or no? She got more? Okay. We don't. Yeah. All right. Court does call the case. People versus Daryl Cope.
Ready, Ron?
All 5 cases.
Ready, it's gonna put the seat by your head.
All right, thank you. Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender with Mr. Cope on cases 53, 1077, and 1336. Mr. Cope is present in the courtroom. Good morning, Your Honor. Marcia Kracher, Cope in file ending 1711.
And what are we doing?
We requested some additional discovery in this matter. I know that this is working on it, and we are asking for a briefing on it. In my 2 matters, I initially thought my client would be asking for an adjournment in my 2 matters, Your Honor, but he has requested to proceed to exam. I've explained to him that there are some media information that I'm aware of that I have not yet received. I explained to him that if we do set this for exam, that if I don't have that media, the exam would not be adjourned. He understood that and still wishes to proceed to examine my 2 cases.
that correct, sir?
Yes, sir.
And you have 1530, 1711.
That's correct, Your Honor.
And on the other matters, we're adjourning those?
Yes, yeah.
All right. The other two matters, how much time did you need? 28th work for you?
That would be fine. Or we could, or a sooner date, either way.
Sooner.
A sooner date would be fine.
Everybody keeps rushing. That's where they end up incarcerated. I'll set it. You want 2 weeks out? 21st,
Thank
May 21st, 2026. 9 a.m. On the other matters, you're no longer requesting on 1530 and on 1711, you're no longer requesting the adjournments, correct? And discovery is not complete. Is that a correct statement, Ms. Cratcher?
That is, Your Honor, I do not have some media. That is correct.
And so you do understand that that won't be the basis for an adjournment?
I understand.
Preliminary,
Today? I'm sorry.
pardon?
Today?
What will be today?
The,
No, he was going to give us a date.
oh, I'm sorry. I apologize. I apologize.
We're on the 26th, correct? Preliminary examination will be set, May 26, 2026, 9 a.m. That's before me. Both cases.
Thank you, Your Honor.
Bond continued. Thank you. This one, I adjourned those to the 23rd.
This is the waiver.
Pardon?
This is being signed because it has the sheet.
Oh, the waiver. What's the case? On Chavez? Oh, no, don't worry about it. That was an AG case. Just send it up. They'll get information to us. Derricka Braddock.
Michael Free is appearing on behalf of the people.
I'm here.
Assistant Public Defender Davi Lebo for Ms. Braddock. Braddock, could you state your name?
Derricka Braddock.
All right, what are we doing?
Your Honor, we'd like to set this matter for a preliminary examination, please.
All discovery is complete.
It is, Your Honor.
People have their witnesses available the 26th.
Yes, Your Honor, we should.
Preliminary examination in person will be set for May 26, 2026, 9 a.m. That's before Judge Freshour.
Okay.
Bond continued. That's an in-person proceeding, ma'am.
Thank you, Your Honor.
Okay.
Thank you. Court calls the cases of the people versus Lewis Gaines.
Your Honor, bring people.
Ready, Your Honor. Sir.
Your name, sir?
Lewis Gaines the third.
Thank you.
Your Honor, we were able to get him screened for mental health recovery court. Based on that, Mr. Cook is going to provide an offer. We would ask for a 1-week adjournment so I can have ample time to explain the offer to my client. We just found out he was eligible for mental health court yesterday.
Gonna have all the signatures and everything in 1 week?
I know that my signature's already on there. I believe everything's already set up. I just need to get the fleet paperwork over in this.
Got it.
Mhm.
And it's out, May 21st, 2026, 9 a.m.
We will endeavor to get that done, Your Honor.
Bond continued. Thank you.
Your Honor. Thank you.
Yeah. Court calls case people versus Daniel Polgar.
Jake County for the people, Your Honor. We're on behalf of Mr. Folger.
Who will be approaching the podium and standing to my right. Mr. Polgar, when you're done here, please state the record.
Daniel Polgar. Thank you.
And at this time, we are asking for a brief adjournment.
You can't do the 28th because what, you're getting married or something?
I mean, about that time, yeah.
Bill says she's gonna do it.
Yeah, people are trying to talk her out of it, but
Okay.
around.
Talk to, yeah, okay. Somebody talks her out of it. Let us know so we can set your cases.
Certainly.
The
following week will be fine.
Following week will be fine. Sorry.
Judge.
You know I have to teach you, right?
I was ready for it, Judge.
June 4th, 2026, 9 a.m. Bound to continue.
Thank you very much.
Thank you.
Want to go quick?
Court calls the case People versus Mario Burt.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
And good morning again, Your Honor. Assistant Public Defender Davy Lee before Mr. Birch. So just sign right there. And Mr. Birch is executing the waiver form.
2017 was case. Okay, so
Mr. Burt, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that a preliminary examination proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the single count.
Your Honor, we acknowledge receipt of the information. We waive formal reading and stand mute.
But in having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
May 26th at 1:30 with Judge Kunke.
May 26, 2026, 1:30 before Judge Kunke.
Thank you, Your Honor.
Bond will continue. Thank you.
Thank you.
Go talk.
Court calls the case People versus Alyssa Nala.
People.
Good morning, Your Honor. Make this honorable court, David Burgess on behalf of Alyssa Nala. Anala, sorry. Anala, no, never get it right.
All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of attempted fleeing and eluding fourth degree, the 1-year offense. On our successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
Correct, Your Honor, that is under the penal code, so the defendant does intend to, Mr. Burgess is going to reach out to Mr. Chabalowski to provide additional information to get our assent to a heightened sentence as well, which is why we have changed the charge to be under 750 code as opposed to the 257.
But at this point, it's not part of the agreement.
That is correct.
Obviously, it'd have to be sought and approved by the court regardless, Your Honor. So, but that's our understanding of the plea agreement. So,
all right. May I have her sworn?
His right hand. Solemnly sworn to affirm the testimony I'm about to give will be the truth, the whole truth, and nothing but the truth.
Alyssa Anna.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of attempted fleeing and eluding fourth degree. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that? All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1483 District Court.
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights?
Oh.
Please, at the paragraph 5, you'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on there.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you? You're doing this voluntarily of your own free will. And because you believe that you are indeed guilty of this offense?
Yes.
February 19, 2026, a location of 5660 Jackson Road, Scioto Township, Washington County, State of Michigan. Were you operating a motor vehicle?
Yes.
what happened that makes you think that you're guilty of this offense?
Can I have what, Your Honor?
Yeah.
Thank you. On that date and time, ma'am, you were operating a motor vehicle
Yes.
and the police came behind you at some point, is that correct?
Yes.
And they activated their lights and or sirens, is that also correct?
Yes.
And you failed to stop immediately. You eventually stopped, but you failed to stop immediately when they activated lights and sirens, correct?
Yes.
Okay.
All right. Ma'am, I do need you to understand that if I accept your plea, between the time I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea and the court would no longer be bound by any sentence evaluation or recommendation. You understand that? Is counsel aware of any other promises, threats, or other inducements which have led to this point?
No, Your Honor.
And have I complied with the court rule?
You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing will be July 6, 2026, 9 a.m. before Judge Fresh Hour. Bond.
Thank you, Your Honor.
Court calls case People versus Philip Patrici.
Your Honor.
Morning, Judge. Larry Margolis on behalf of Mr. DiPatrizio, who approaches from in custody. May we approach?
Briefly.
Thank you, Judge.
Go ahead.
Thank you for that conference at the bench, Judge. We are prepared to proceed as discussed.
All right. What did you want to do regarding the violation?
We will admit to violation.
Is that correct, sir?
Yes.
Anything you want to say before you went in last Thursday, the 7th? Friday, the 8th.
I brought myself there Friday. Right when I found out, yeah.
All right. Sir, you're going to have to understand what the rules are. You're not to have any contact with the alleged victim in this case, either directly or indirectly. You understand that?
Yes, I'll do.
And as I was explaining to your counsel, and your counsel will explain it a little bit more, these contacts that you may believe are minimal are not minimal in this court's eyes. So when this court tells you no contact, I'm going to let you know expressly, I mean no contact, and I'm not going to tolerate it. And if it happens again, there is no argument your attorney's going to make. You're just going to sit in jail. Are we clear?
Yes, very clear.
I'll sentence the defendant to 10 days on the violation, credit 7. He's to serve the balance of it then be released. All right. What are we doing with the case itself?
We may as well set it for exam, Judge. We're ready. We've received all the discovery.
People have their witnesses available tonight, the 26th. Preliminary examination, each person. Hello. Preliminary examination will be set 2026, 9 a.m. before me.
Thank you, Judge.
And we'll continue. Thank you. Court calls the case, People versus Brian Laster. Cases. He's in there. Got it.
Morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Laster.
Mr. Laster, could you state your name, please, sir?
Brian Ian Laster.
Thank you. What are we doing?
Your Honor, I have read the report, and at this time we would stipulate to the findings that Mr. Laster is not competent, but can be restored to competency. And
well,
I do believe I submitted.
Hold on a second. I have that he's competent.
What's the date, Your Honor?
Well, I see. No, I have that he's not competent. State trial, the April 20th. The order doesn't reflect that.
Thank you, Your Honor. I also show a letter that he's been applying incompetent and like to be restored.
Restored. Yes, I see it now.
Given no additional evidence, we'd ask that the court adopt after the court in order to find that or be restored.
That is what we're doing as well.
All right, I will find based upon that the defendant is incompetent to stand trial, but restorable. I will set a review date on this for and August 13, 2026, 9 a.m. All of those orders, their orders are wrong.
Awesome.
Thank you. And I did not put dates on I didn't put any dates. Court calls the case. We're all set. Thank you, Mr. Laster. Court calls the case, People versus Amanda Brown.
Morning, Your Honor. Good
Morning, Your Honor. Please, Honorable Court, David Burgess on behalf of Amanda Brown, standing to my right.
Your name?
Amanda Brown.
All right. You need an adjournment on this.
She was just arraigned the other day, Your Honor, so we'll just need discovery.
28th work?
Fine.
Probable cause conference will be adjourned May 28th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor. I'll take two.
Court calls case, People versus Timothy Cottenham.
As well as the people.
Good morning, Your Honor. Good morning to your staff. May it please the court, Lieutenant Verb P 8437 on behalf of Mr. Cottingham. Just approaching my right, sir. Could you state your name for the record?
Timothy Cottingham.
Thank you.
Date and time set for PCC, Your Honor.
No, go ahead.
We are requesting that preliminary exam be set for the 4th. I do understand generally this court states. We have an issue.
Hey, don't give out the dates.
I mean to say the party doesn't request the dates, the court generally advises it, but we do have an issue from last week. The people turned over 200 pages of medical records with some redactions. The issue is there isn't a privilege log attached to those redactions. Really, I have 3 parts that are problematic. One is a redaction of an MRN, so I can't tell the complaining witness's medical records or if there's additional medical records available with regard to that one specific medical provider. The other 2 parts I do take issue with are the people essentially pick and choose what diagnoses are irrelevant and redacted certain diagnoses from different timelines. The last portion is certain medications that were redacted.
The what?
Certain medications were redacted in those 200 pages. The issue is I can't tell right now. Based on that, I am moving that this court strike those redactions and give defense the.
How am I going to strike redactions on medical records and I haven't seen them? I mean, how would I even begin doing that?
Your Honor, we could file a motion and subsequent brief in support as it relates to those records, if the court wants to review all 200 records.
Well, I don't know how I would grant, you explain to me how I would grant your relief without seeing the medical records or without specifics as to what you're saying should not be redacted.
It's a confrontation clause issue, and I think there's a progeny of case law both in Michigan, no fault, and I understand this is a criminal case, but the standard comes from United States v. Ray, as well as there's another case.
I understand the standard. How am I going to do it?
The court could issue an order striking the redactions from the people's discovery that was produced last week.
Wouldn't that be reckless on my part? Because there may be things that are properly redacted. And if I just give a blanket striking of it, that'd be reckless on my part, wouldn't it?
I don't believe it would. The people have turned over the address, the date of birth, specific medication information, but now we're at a point where they're picking and choosing both medications.
I don't know that. That's what you represented to me. And then you represented it to me, and now you want me just to strike all of the redactions where some of the redactions may be proper. But I still get to the bottom line. I don't know. How would I know without seeing?
Your Honor, we'll file a motion, attach those records as an exhibit, and leave it for discretion beyond that.
Response.
I did redact out the victim's MRN number. I think the court's familiar with how MRN numbers function in medical records. And that number, along with all of the other information they have about the victim, including his address, his date of birth, other information, combined with the MRN number, could be used to get even more access to his private medical records. I did redact out a diagnosis, a prior medical condition, because I did not think it was relevant to these proceedings. And the victim does not give up all of his rights to medical privacy just because he's been the victim of crime. And I did redact out a medication, Your Honor. I'm happy to provide the unredacted records to only the court for in-camera review, so we can sort of see if the court agrees that these redactions were appropriate. But I do believe that the victim, he did not choose to become a victim in this crime. And as the court is aware, when you receive medical treatment at a hospital or at a doctor's office, oftentimes your prior medical history, your prior diagnoses, and other information about you, including medications you are prescribed, can become a part of that medical record that is generated as the result of an assault. And the items that I redacted out, I do not believe are relevant. I frankly don't think they're anyone's business except for the victims. But I'm happy to provide the 200 pages of unredacted medical record to the court for the court's opinion on that matter. And if I am wrong, I'm happy to provide unredacted copies. But I believe the people have made those redactions in good faith and with the basis in the privacy of the victim.
Anything else?
Very briefly, Your Honor, I don't believe it would be within the government's discretion to determine relevance. I believe that's a matter for the court.
How long will it take you to file your motion? I mean, I think you're wrong, but how long will it take you to file your motion?
Your Honor, I'd ask for a week, and I'd ask if we could set the exam for the 4th.
I'm not going to set an exam until discovery is complete. I'm not doing that. I mean, why would I? I don't know where this is all going to lead. I have no idea. So if you're going to file your motion, you can file your motion by when?
I'd ask at least until the 21st, Your Honor.
And the people will file their response. Can you file that within a week with a copy of the medical records by the 28th? Or how do you want to do this?
I can file a response to the motion by the 29th if the court would allow that following Friday.
That's right.
Thursdays tend to be a little bit of a busy day for me, Your Honor.
Think?
They do. Yeah. And I can file it by the.
I don't know. Thursdays are rather relaxing.
I know.
All right.
Yes, Your Honor, I don't want to file unredacted medical records in the court file, but I can make arrangements to physically bring them
Yes, correct.
and have them sealed and presented to the court in such a way that they will not become a part of the court's file.
So yes, so your answer will be due by May 29th. And then, the records, the unredacted copies should be sealed and should be delivered directly to my staff in person, either myself directly or to Ms. Weidling.
I'm sure I can make that happen, Your Honor, by the 29th.
By the 29th. Then set a hearing on this. Medical records trying to get through by the 29th. Set a hearing on this for June 11th, 2026 at 3 p.m. on the motion, the discovery motion. I'll adjourn the probable cause then also to that same time of June 11th. Once we get this issue resolved, then I'll be more than happy to set the exam.
Thank you, Your Honor.
Thank you.
Bond will continue. Court calls case B versus Matthew Kennedy.
Your Honor, I think it's good.
Morning, Your Honor. Please tell Burgess on behalf of Kennedy, Your Honor, who does not seem to be present today.
Matthew Kennedy, you're on both of his cases.
It's just the one. I think the PD is on the other one, Your Honor. Judge, last time we were here.
No, I got you on both.
Okay.
I have you on both.
All right, then I'm on both. Last time he was here, he was indicated he was at Bear River, Judge, and he was indicated that he was leaving in the next couple of days. I tried to contact Bear River to see if they put him on this morning. They didn't. They wouldn't disclose, but they said they would if he was there. However they do that.
Yeah, I recall that he was there when he was supposed to be releasing. Kind of timed this out to whatever, but he's not here. Bench warrant will issue in both of these matters for the defendant's failure to appear. Bond set at $10,000 cash surety.
Yes, sir.
All right, thank you. Court calls case People versus Denerius Williams.
Your Honor, Sam Bernstein with and on behalf of Mr. Williams, who is coming up to the podium. Williams, could you please state your name?
Denerius Williams. Thank you.
Your Honor, we're asking the court to please set this for exam. Discovery is complete.
All right. Preliminary examination. Would the people have their witnesses available the 26th? Well, okay. Preliminary examination, May 26, 2026, 9 a.m. before Judge Fresh Hour. Bond will continue.
Thank you, Your Honor.
Excuse me. Court calls case People versus Morgan Gillander.
Morning, again, Your Honor. It's for David Burgess. I'm from Morgan Gillander. Apparently, Judge, nobody likes
lonely
Your Honor
for you. Yeah.
one of my other clients is still here, Judge.
Okay.
So, but I just texted Ms. Gillander this morning. I was in contact with her last week. I have no idea where she is, Your Honor. Sorry.
For the people, I would request a bench warrant, Your Honor.
Bench warrant will issue for defendant's failure to appear. Bond set in the amount of $10,000.
Yeah, try not to take it personally.
Pardon?
I'm trying not to take it personally.
Okay, understood. Court does call the cases of the People versus Kelly Joe Grubaugh.
Morning, Your Honor. Raymond Cook for the people.
Morning, Your Honor. Edward Duke, Edgar Ball in all matters.
Name?
Kelly Grubaugh.
All right. What are we doing?
Your Honor, this is a waiver.
Waiver on all of them?
On all.
Well, you're waiving your right to a preliminary examination in all of these matters? You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. Yes? All right. You understand you will not have that hearing on any of these matters and that you'll proceed to circuit court for further resolution. You understand that, ma'am?
Yes, sir.
Oh, I see how they do. People also waive their right.
Yes, sir.
Preliminary examination having been waived in all of these matters. Preliminary defendants bound over to circuit court on the single count in each case and on both counts in the case ending in 0482 on both counts 1 and 2.
Thank you. We would acknowledge receipt of the stand mute, waive reading to all matters.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea as to all 5 counts, if that's right. Pretrial in this matter will be set for
June 1st at 1:30 with Judge Hamoud.
June 1st, 2026, 1:30 before Judge Hamoud.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls the case, People versus Jennifer Robinson.
Jake Kennedy for the people, Your Honor.
Good morning again, Your Honor. If this is on the court, David Burgess, on behalf of Jennifer Robinson, who is here.
Hello, what's your name?
Jennifer Robinson.
Thank you.
Your Honor.
So I know. So good.
It does, Judge.
Have a client.
The relief.
All right.
Should take my Lexapro or anything. Judge, discovery is complete. Can we have an exam day, please?
Yes. All right. People have their witnesses available the 26th. All right. Preliminary examination in this matter will be set in person May 26, 2026, 9 a.m. before me.
Okay.
Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case People versus Javante Prior.
Alyssa Nala on behalf of the people, Your Honor.
Oh. No, take your time, Cannon.
Your Honor, I came as quickly as I could. Stephanie Cannon on behalf of Mr. Pryor. I'm old. On behalf of Mr. Pryor.
Whatever. Mr. Pryor, can you state your name, please?
Javante Prior.
Thank you, sir.
Your Honor, this case, you should have a green sheet. We're asking for a brief adjournment for investigation and mitigation purposes. I've actually prepared an order for treatment.
For release to treatment, you mean?
Yes, for on GPS tether. If I present that to the court in just a bit, I can't print right now with the court being inclined to allow him out for treatment.
Any objection from the people?
I feel like I would be objecting to this, but I feel like I would want more information on where he would be given the facts of this case. This is a strangulation, a serious strangulation involving a victim being strangled to the point of unconsciousness. And I would have.
I understand that, but if there's a belief that treatment would be necessary, I'll sign the release. They're not going to release him unless they make the assessment first, and then so I'd sign that order, present it to the court.
Thank you, Your Honor.
And I'll adjourn this matter out to the 28th. 2029 a.m. Bond continued. Thank you. Court calls case People versus Hosea Hill.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Edward Lucas on behalf of Hosea Hill with approach. It's coming up.
Your name, sir?
Hosea Raphael Hill.
All right.
Your Honor, 2 matters today. One, I turned in a green sheet. We're asking for a brief adjournment so we can review the discovery a little bit more in depth and continue to negotiate, like to address bond at the appropriate time.
Probable cause conference will be adjourned to May 28th, 2026, 9 a.m. Yes, that's the bond.
As to bond, he was remanded last week, Your Honor.
He was.
He wants to apologize today. He wants to get out, head back to community correction.
What would he be apologizing for?
We have discussed attitude And I think that attitude will be corrected the next time that he attends community corrections. I think that we've had a long discussion regarding how to deal with direction and deal with other people. And I think that attitude will be a change to what was previously.
Response from the people.
Correction, the court's aware of the facts and circumstances, sort of what, how Mr. Hill's been conducting himself. So.
Did he send an apology letter over to?
I believe that the previous public defender did send something over to her.
Did he send it over?
He's been in custody. I don't think he's done it while he's been in custody, but I certainly can arrange for that to occur. And I did speak with his social worker. So it is something that there's more eyes that are going to be on him regarding moving forward.
There needs to be an apology letter that goes over. I'm not even going to consider release till that apology letter gets to community corrections. That's number one.
Okay.
And once that letter is there, you can attach the letter to an order permitting his release.
Okay.
I will then tell you, Mr. Hill, those individuals over at community corrections do a great service to people who we can release into the community. They do a lot of the monitoring. I will, otherwise everybody pretty much in here would be in custody. I will not, at least while I'm here, ever allow them to be respected in any way. Any way. Am I understood?
Yes.
So once that letter's done, once it's over there, you can be released. I will reinstate his bond. But if I hear at all that you did something disrespectful, even if you looked at him disrespectful, I'm going to lock you back up. Am I clear?
Yes.
So at this time, I'll have his bond continue.
Okay. Thank you, Your Honor.
Next. Court calls again versus Melissa Allison.
Morning, I'm bringing cook for the people.
Assistant Public. On behalf of Ms. Melissa Allison, who's approaching.
This will just be. Well, one of them has one.
Say your name for the record. Melissa Allison.
Go ahead.
Because we're asking to set this matter for preliminary examination.
We'll have their witnesses available the 26th.
We'll do our best, Your Honor.
Preliminary examination person will be set May 26, 2020, 9 a.m. before fresh hour.
Thank you, Judge.
Bond continue. Thank you.
Thank you. I'll do this.
Court calls case People versus Travis May.
Good morning, Your Honor. Edward Rugerson, Travis May.
Your name?
Travis May.
Thank you.
Thank you. We're asking for a preliminary examination.
Preliminary examination. Discovery is complete.
My knowledge, Your Honor.
Now address the court, please. We'll have their witnesses available on the 26th. Preliminary examination in person, May 26, 2026, 9 a.m. before for me. Never even put on the record. Nothing I understand. Is there something else?
Yeah, Your Honor, as far as addressing the court, I have been doing my own footwork as far as getting into treatment. Every violation that I've had on the PR bond, what cause of drinking alcohol, and I'm an alcoholic. I need some help with this. As far as discovery, this case has been going on since March 9th, and I haven't received the discovery. Pardon? I haven't received my discovery since March 9th. This case has been ongoing. And haven't received your discovery? No, my discovery package.
I think he wants to also review some of the videos as well.
Yes.
But, Your Honor, with regard to the treatment, we're working on getting him released to treatment. We're working on getting his address to into Washtenaw County. And so that's holding things up. But regarding
I already have a bed available, Your Honor. As I said before, I have been doing my own footwork because I need the help. I'm asking for the court to intervene and to get me some help because every violation.
Sir, all I can basically do is sign the order. If somebody finds something and I deem it appropriate, then I will do that.
That's what I was at today. I was asking for myself, for my life. I need treatment. I'm asking.
Okay, I understand that, but I can't just pick it out of the air.
Well, my lawyer needs to address that point to you and to the prosecutor that
sir, maybe you don't understand something.
Okay.
But the number of people that appear before me, if you're making some dig at Mr. Drukas, I think he better stop right now. Because Mr. Drukas will always advocate for his client to get into treatment.
Yes, sir.
If you're making some dig at the prosecutor's office that they're not doing something to try to help you or to assist in that process, you're wrong. They will also cooperate in the process to get whoever needs treatment into treatment. So you're way out of order if that's what you're doing.
That's not what I'm doing. I'm just really advocating and putting for the record myself and how I feel about my life.
And your attorney has done that. I understand, but your attorney has done that.
I'm not trying to blackball my lawyer. Me and him, we got a good rapport. I'm just, if I don't speak for myself, then, he's supposed to speak for me. And I feel in all matters of my life, even like this case right here, I'll speak for myself.
Mr. Drukas and I had a good discussion this morning about this case and about Mr. May. I very much wanted Mr. May to consider some sort of sobriety court, drug court, treatment court, something. And I understand he's not interested in that. So we're proceeding to assume.
And then in reference to that, lady prosecutor, I would very much be.
And Your Honor, I'm going to stop you. I don't want you addressing the prosecutor directly, but I'll work on that. So, Your Honor, I think at this time we're going to proceed to exam, and him and I are going to work, and I'm going to get him another
26, 9 a.m. before me. Bond continues.
Thank you, Your Honor.
Court calls case People versus Deja Banberry.
On behalf of Your Honor, but I don't believe with Ms. Banberry at this time. Your Honor, I would ask if the court would be inclined to adjourn this matter. My client has not missed once, to my knowledge.
It's always a first.
Yes. I did speak to the prosecutor regarding this, Your Honor. Can we approach?
Oh.
Please.
Why?
Please, because I'm old. I just, please.
Come here.
Okay.
Just come on. People versus Jari Bagwell. 2 cases.
Robert, on behalf of Mr. Bagwell, the case ending in 0623.
And Assistant Public Defender Tanisha Moore on behalf Bagwell on 1361 matter, Judge.
Thank you, Your Honor. Today's the date and time set for, Mr. Bagwell, please say your name.
Jeremy Bagwell.
Thank you.
And Your Honor, today is the date and time set for probable cause conference. We are working on a global resolution for this matter. It's also my understanding that the people have additional warrants pending for Mr. Bagwell, so we are asking for additional time.
All right.
That's our request as well.
So that need reviewing or what's happening with those?
It was in the file that there's 3 additional warrants currently reviewing, as well as one of the matters set for this case, there might be an additional charge.
Got it. Can we get all of that resolved or at least sorted out by the 4th? Yeah.
Who do I must hear?
What 4th were you thinking of? Okay. Any objection to that by the defense?
No, Judge.
All right. During these matters, June 4th.
Thank you, Judge.
2026, 9 a.m. Thank you. Bond continued. Court calls case People versus Rashan Mangoria.
That's adults for the people.
I think that is.
Oh, Rashan, I apologize. Assistant Public Defender Chinaki Kiriak, really on behalf of Mr. Bangora. Rashan, state your name for the record.
Rashan Mangoria.
Rashan.
He like apologized to him, did apologize to me. You see that? Did you see how that happened? All right.
Your Honor, we would be asking for an adjournment. I do believe all the discovery, I did not have the media, but I've confirmed that I do have it and I just need to review it with them. I do.
28th work.
That should be fine, Judge.
I don't know why he sneak Bagwell up here. Yes, you did. You just. Yeah, I know, but she just snuck her green sheet up with this one. Like we would not know. Will the 28th be enough? Why don't I do this? June 4th, 2026, 9 a.m. Bond continued.
Judge, can we just address bond very briefly? Yeah, that's the main thing. Your Honor, my client currently has a tether. It's a GPS tether. He indicates that he is getting ready for graduation, and graduation is on
The 6th.
June the 6th.
June 6th.
Okay.
Okay.
We'll reconvene on the 4th then. Yeah.
Okay. I understand.
Yes. Thanks, Judge.
All right. Thank you. Court calls the cases of the People versus Shaquille O'Neal. Huff.
Good morning, Your Honor. National Atlantic Belt is going to be both.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender. Yeah, and Mr. Phillips.
How you doing? All right. What are we doing?
Your Honor, we received the report. I believe it's like May 1st or April 30th.
Yes.
And it continues to recommend that Mr.
That he's incompetent and
That is correct.
will obtain competency within. Then is there any other additional evidence?
I think we would ask the court accept that report and continue to work to very good.
We'll find that at this time the defendant remains incompetent to stand trial, but likely to treatment. To do that, I'll adjourn this. I'll set a review hearing.
August 13th.
August 13th, 2026. He's good. 9 a.m. Bond continued.
Thank you.
Court calls the case People versus Maurice Boyd.
Joy, Senior Assistant Public Defender representing Mr. Boyd, who should be.
Maurice
appearing by-
Deshawn Boyd. Thank you, sir.
Your Honor, we are requesting an adjournment for ongoing negotiation.
Probable cause conference, June 4th, 2026, 9 a.m. bond continued. Thank you. Thank you, Mr. Boyd.
You're welcome. God bless.
Court calls the case People versus Laura and Dia.
Assistant Public Defender, Tanaka here. On behalf of Ms. Laura and EST.
She is.
Cheers.
I know.
The door was closed. Then do you state your name for the record, please? Laura. Yeah.
Thank you.
Your Honor, we're asking for an adjournment in this matter. We are in negotiations with the people and I've laid out the options to Ms. Andia, so we're just waiting for her to decide which way she'd like to.
May 28th, 2026, 9 a.m. bond continued. Thank you.
Okay.
Court calls the case People versus Natasha Brazil.
Very good. People. Four show fees for Assistant Public Defender on behalf of Ms. Brazil.
I'm here.
Oh, she's here. I just please state your
Tries, huh?
yes, Judge. Please state your name, Ms. Brazil.
She doesn't have a camera on. There she is. State your name.
Natasha Brazilton.
Thank you.
It's such a surprise, Judge. I did not prepare a green sheet. I did not think that Ms. Brazil.
Shanaza's got extra. Go ahead. What?
We have had no contact, Judge, with Ms. Brazil. Requesting a 2-week adjournment and asked the court to have her call her office with good contact.
All right, Ms. Brazil, then what I'm going to do is I'm going to adjourn your PCC to May 28th, 2026, 9 a.m. Got that?
Yep.
And I need you to call the public defender's office.
Okay.
Okay. So do you have that number?
I do not.
You got something to write with?
Yes, I'm grabbing it now.
It's not myself.
Okay, what was that number?
Is area code 734 222 6970.
You said 734-222. What was last four?
6970.
Okay, thank you.
All right, call them, make sure they have a good phone number and email for you.
Absolutely. Thank you.
All right, thank you. We'll see you in a couple weeks. That's what it looked like. Huh? Yeah. Who was on that case? That was you and who else?
Myself here.
Yeah, come here, both of you.
And we are told that it's better to do the signatures on when they come up here rather than in the back.
Who told you that?
Oh, I don't remember their name, Judge.
Did you say that?
Oh.
You just made that up, did you?
I did not, Your Honor. I did not. I did not.
May I have him?
Raise your right hand. Solemnly swear to affirm the testimony you're about to give the whole truth and nothing but the truth, so help you God. State your name, please. Tyon Davis.
Plea form that I finally have indicates defendant will be pleading, well, it doesn't tell me how he's pleading. I'm presuming guilty.
It will be a guilty plea, Judge, yes.
So the box wasn't supposed to be checked either. Okay, never mind.
Slight oversight.
So he's going to plead guilty to the charge of use of a controlled substance, that being cocaine, the 1 year offense. On a successful plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement.
And Your Honor, what I failed to add on there is people do not have an objection to 7411.
That's correct, Your Honor.
You want me to give it back so you can fill out the form?
I can, but oh,
No. I'll take my time in writing.
thank you so much, Your Honor.
Please, no objection. No mind. All right. So now it indicates that there's no objection. The prosecutor agrees that there's no objection to 7411 sentencing.
That is
That's the
correct.
court's full understanding of the agreement now.
That's everything we have as well, Judge.
Okay.
Okay.
Go ahead. Really? Take the conversation?
Nope.
Oh, no, go ahead. I'll wait. Are we done?
Yep, we're all set, Judge.
Sir, to the charge of use of a controlled substance, how do you plead?
Guilty.
Now you understand by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights for today just now, right?
Yes.
Any question regarding those rights?
No, when I'm going home, no, I'm just playing.
Look at paragraph 5. You see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal upright.
I do.
Are you on probation or parole?
Mm.
Were you on at the time of this offense?
Yes, Your Honor, he is on probation with 14B, but he's currently serving a 93-day sentence to close that probation matter out.
Gotcha. Okay. I just want to make sure, well, I do have to advise you that if you were on probation at the time, that this could be a violation of that probation. And if it is considered a violation, the court could sentence you to the maximum allowable under that other charge. You understand that?
Sure.
And understanding that you still wish to plead guilty to this charge. Is that correct?
Correct.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will,
Sir.
and because you believe that you're guilty of this offense?
Correct.
October 7th, 2023, at the location of 2201 Hogback Road, that being the jail in Pittsfield Township, Washington County, State of Michigan. Did you have cocaine in your possession? Had you used it?
Correct.
And did you know what you were using was cocaine?
Correct.
All right. Sir, I do have to advise you of commit misconduct between the time of my acceptance for your plea and the time of sentencing. Misconduct is defined in the Michigan court. You would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. We understand that, sir? Is counsel aware of any of the promises, threats, or other inducements which have led to this plea?
Defense is not, Judge.
And have I complied with the court?
Defense is satisfied as well.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be
May 27th at 12 noon.
May 27, 2026, 12 noon. That's before me.
Thank you, Your Honor.
Thank you. Bond continue. Court calls case People versus Trayvon Bridges. Trayvon Bridges.
Good morning, Your Honor.
Assistant Public Defender Chinazi Carey, I can really, on behalf of the Bridges, who should be approachable.
He is. He's right there.
Say your name for the record, Mr. Bridges.
Trayvon Bridges. Thank you, sir.
Your Honor, we're asking for an adjournment in this matter to continue negotiations with the people.
Probable cause conference for 2026, 9 a.m.
Okay.
Bond continue.
Thank you.
All right. Thank you, sir.
Thanks, I'm here, folks.
Yes, exactly. Yeah. Court calls the case People versus Taiwan Griez.
People. Jazmine Cannon on behalf of Mr. Griggs.
Thank you, Your Honor. His sister showed up. She wanted me to make sure he knew. So, Your Honor,
Sure.
please state your name, Mr. Griggs.
Taiwan Griez. All right, thank you. All right.
Your Honor, I believe a green sheet has been presented to the court for for a negotiation. In this case, I am in communication with the prosecutor's office regarding him. There will be a potential sobriety court screening as well in his case. So we are asking for an adjournment. My client did want to talk to you about potentially hiring different counsel. If you still want to have that conversation with the court, you can, Mr. Griggs.
Yes, I was just going,
He hasn't been screened as of yet.
For a sobriety court, not yet, no. We talked about this Tuesday.
I'll adjourn it out to June 4th. See if we can get a screening 2026, 9 a.m. Yes, sir.
Well, I also was wondering if I would be able to PR and get, proper counsel so I could be able to handle.
Get proper counsel?
Yeah, I've been in.
What does that mean?
I just been in the wind, past the last 7 months about.
What's that mean, proper counsel?
Well, I feel confident.
You don't have proper counsel now?
I mean, I didn't talk to anybody before I came in, so I don't
really.
I'm not trying to go back. I want to be disrespectful, sir. I'm just.
Well, I don't. You can be disrespectful to me, but that woman standing next to you.
I'm not trying to be.
Because we're gonna have a real problem.
It's just. I want to be able to get a. I have civil case as well. Just counsel along my cases. It's like I'm not trying to be a flight risk or anything like that. I'm just trying to do the best that I can. And I want to do apology. For previously coming in here, I caused a lot of chaos out there.
So what are you asking me to do?
If I could possibly just get a, PR so I could take care of other things.
My client has a warrant.
Oh, he wants you to speak for him now? No, I mean, I don't know. He said he was going to get a real attorney.
I'm Your Honor. So to help Mr. Griggs out here.
Oh.
At the beginning, he is under the impression that our office is the one that deemed him incompetent. So his issue was more with the public defender's office than with me. At least the last time we spoke. That's when we spoke on that day. I tried to explain that situation and circumstance to him and how it works. And I let him know that if he did want to seek outside counsel, that is, of course, his right to do so. He wants to be released because he has a hold in another county. And I did present an order to the court, which the court did graciously sign to allow him to be released to treatment.
To treatment.
But until the hold is cleared up, he can't. A paralegal request has been done and our office is attempting to help clear that hold for him. And I do believe we've been in contact with the jail regarding it to see if we can work both in.
Work around that.
Yes, Your Honor. So we are working on the hold on our end as well. I do believe, did I articulate everything you discussed with me, Mr. Griggs?
Yeah, for the most part.
Yes. And so that is his reason for asking.
For the most part, what's the other part?
Oh, it's just my issue that I had with the prosecutor's office, that's the main thing, because I had other cases and he said something that was not on the police report that deemed me to portray an image that was not true. And since the 7 months that I've been in here, some issues happened.
And we're also getting the prosecutor's office is looking for the additional discovery that I requested in case number 2. You responded saying, let me get that to you. Yes, and so they're working on getting that as well.
Okay. Any response from the people? I'm sure you do.
Your Honor, I would object to any change in bond. These are both R&O cases, one in 2024, one in 2025. The incident in 2024, one of the officer's shoulder was dislocated.
My My client just outran the officers and the officer tripped. So he didn't attack. He wants to be clear that he didn't attack the officer. That's the thing for him, Your Honor. He wants the court to actually physically attack.
Yeah, I mean, I'm not a violent person. I'm a pacifist at heart. So it's like I do diligently try to be the best person I can be. But like I said, there was other things that happened before me coming into court where I was spoke out as well for the second cases of R&Os.
So let me get this right. You outran the officer fell.
And I stopped because he fell. And, and it's like, dude, it's like.
Stopped and went to help him.
I stopped, then the other officers tackled him. And then I ended up going to the hospital because.
More than one.
Huh?
There were a whole bunch of officers following you?
It was 3 officers.
3? Okay.
Gotta.
All right.
Well, when you make
anything else?
If this on the record, it's reported. So
I'll wait for
talk
the
about the cases.
officers to testify about.
Yeah, yeah.
I have concerns about flight risk and ability to remain law abiding while out.
True. Motion for bond reductions denied. Bond will continue. Thank you.
Talk to you about it, okay? Yep.
Donovan Buckner.
I'm here, Your Honor.
Hey. And Assistant Public.
No, talk to me.
Here. On behalf of Mr. Buckner. Mr. Buckner, could you state your name for the record, please?
Donovan Buckner.
Thank you, sir.
Your Honor, we're asking for an adjournment in this matter. We have not been able to make contact with Mr. Buckner. We did send him an email, but we have not heard back from him. So I'd ask that the court have him contact our office.
All right, Mr. Buckner.
Yes, sir.
Contact the public defender's office.
Yes, sir, I will.
All right. Do you have their phone number?
Oh, I believe it is in the email that was sent to me. I will go through it and call them.
You're outside.
Okay. Call them and make sure to return their emails.
I will make sure to be on it, sir.
Thank you.
June 4th, 2026, 9/8. Bond continued. Court calls the case, People versus Stephen Hamel. Mile.
Assistant Public Defender, Chinazi Kariak Rulu, Your Honor, on behalf of Mr. Stephen Hamil, Judge.
Sir, other than in her ear, state your name, please, for the record.
My name's Stephen Hamil.
Thank you.
I'm sorry, Judge.
No, that was good.
Your Honor, we are in negotiations with the people. We're asking for an adjournment in this matter. And we'd like to address bond as well.
Probable cause conference, I'll go to May 28th, 2026. 9 a.m. Yes.
In regards to bond, Your Honor, Mr. Hamil reports to us that he is gainfully employed. He is the sole, his significant other is currently pregnant, Your Honor, and he is taking care of her as well as 4 children. 5 children in total, Your Honor. He understands the severity of these charges. However, he is asking that the court allow him to be released so that he can continue working and financially caring for his family. He is okay with the tether. He lives locally, Judge. I know that the bond at this point is just too much for him to pay. He's not even asked for a PR bond. But if the court could at least reduce the bonds slightly, he would be able to rally together some other family members to assist him financially to post that bond. However, where it is right now, he states that there are a number of things that he needs to be doing for his family and the condition of his significant other. The pregnancy is I don't know if it's considered as high risk, but he states that she's really been having a difficult time. So taking care of the other children have been difficult for her. And that was where he came in.
Response.
Object to a bond modification at this time. I believe this incident involved him showing up at an apartment hearing and looking for his other children. We initially requested a high cash bond with no 10%. And yeah, we would sell issues.
And just very briefly, Your Honor, I have to note that the report does not indicate that he made any threats to anyone with this particular gun, nor did he point it at anyone. It's just the report says that he went to an address and was asking for his children. Obviously, we won't get into details.
Were his children armed?
Yes.
Allegedly.
Allegedly. I like that. Yep.
And he allegedly is a person who cannot possess a firearm.
That is correct, Your Honor.
Motion for round deduction tonight. Bond will continue. Thank you.
I have 20 minutes and come back.
Okay. Court calls case People versus Aaron Burrows.
Ready to go for the hearing?
We're ready, Judge. Portion of these for assistant public defender on behalf of Aaron Burrows, who I am hoping is present somewhere in the courtroom.
I think Bishop knows.
Bishop has the answer? Oh,
Okay, go ahead.
I was hoping.
How do you mind?
Yeah, we have reached out to Burrows. We thought that he would be here, but apparently he is not. For the record, we would request an adjournment, but do not know why they are not present.
Bench warrant will issue for defendant. Your bond will be about 10,000 cash shares. Court does call the case versus Shantia Holloway. Yes.
Good morning, Your Honor. Joy, Assistant Public Defender, and on behalf of Ms. Holloway. Holloway, would you please state your name for the record?
Shantia Janaya Holloway.
Your Honor, Ms. Holloway is here for a bond violation. We've had an opportunity to go over the report together. And she has been in custody since last Thursday, so for 7 days. We are requesting at this time, she is at this time wishing to admit to the violation that she was unaware that the no contact order of the limited nature of the exclusion zone for the no contact order. She had spoken to her spoken to her child's father, who was in need of Pampers and wipes, and they had agreed, instead of her coming there, for her to drop off those items at a friend/neighbor's home in that same area.
Opposite sides.
But on the opposite side, she indicates that when they're was driving around, that she was going to that person's house, and that that was part of what was necessary for her to leave. She understands and is very clear that she does not have a criminal history like this.
I did think, sir.
And she did. It was not as quickly as they would like. She was trying to explain that she was trying to get the diapers and such, and that she was not trying to go over to the house. But I think now she has not had this kind of trouble or been incarcerated on a case for the number of days that she has on this case. And she's really learning her lesson, and this will not happen again. So we are asking that.
Things were also kind of suspicious as to whether or not she had been drinking.
She indicates that she has, I do not know why they, go ahead. Sir.
May I speak, Your Honor?
Did you hear?
Go ahead.
So when the officers came to my godparents' house to get me, they said that it was the tether company that wanted to pick me up. I was on hold with the non-emergency line trying to get a civil standby, but he didn't let me explain that. And it's like when you come inside my apartment complex, the only way that you can exit out is if you have to go all the way down and then come around the opposite side, because it's like gates that they have to let up. I understand the seriousness of the situation, and I am very sorry, Your Honor, but my child really did need those Pampers and wipes. But I still have not had no contact with my kids. I have been blowing, doing my sober link. I have been sober, and then the officer that arrested me, she said that me taking a PB wouldn't hurt or harm me. She just said that if it was up to me, and she didn't say that it was mandatory. So that's why I was like, well, I've already had a signed sober link. Why do I need to take a PB when I did use my sober link that day? And it was a compliance test. That this would not happen again, Your Honor.
And for some additional information, the child who is the subject of the case still continues to reside in Pontiac and was not in any, this was for her youngest child who is with her father. I'm sorry, with her father.
You saw it from the people.
I obviously read the report. It doesn't seem like it was vindictive or anything on the defendant's part, but what's disappointing that it was within hours of us discussing it and discussing how her and counsel needed to go about for taking advantage of access to the younger child. So while the actual context of what she says she was doing and what I tend to believe she was doing is not negative or violent or like that. I just have concerns that kind of disregarded what we talked about kind of ad nauseum last time that we were here. And I have concerns that when asked by police to issue refuse, but I don't have a lot of information from the police as to why they requested that she do that. That's a long-winded way to say that I'm ultimately going to leave it up to you. I think that she needs to continue to maintain her sobriety, but that she needs to also continue to follow the court's orders in terms of where she can and cannot be. And so I'm not going to be that she can see her children at this point in any capacity if she is to be released.
In your own client, if you were to change,
was
the link
going to?
I'm sorry.
Where was she supposedly going to take these diapers?
To a friend's place who lives in the same apartment complex. But it's the one off Grove Lakeshore, so it's a huge apartment complex. So she did not think that taking it to that other person's place so that her partner could pick up the diapers and wipes would be an issue. And she knows now very clearly that that's an issue. She's nodding her head in agreement, and she
When the
And
police
Miss-
showed up, you were upstairs, right?
She was at a different location, but I believe it.
I did leave, Your Honor. It was a quick, it was really quick after I left the apartment complex and I went to my godparents' house. Tell me to leave, so I went and parked my car. And then the police showed up shortly after that. I was not upstairs when they came. I asked them, was I able to change my clothes? And they did let me change my clothes because I had on something prior to when I was at court. It was a dress.
If you look, you'll see that in the report, it gives another address. And it's my understanding that address is not within the complex. And that was where the tether agent or the tether agencies dispatched. And that is not in the complex. It's, as she said, at her godparents' house.
When they told you you were in the zone, why were you arguing with them?
Officer, I'm sorry. So I wasn't trying. I was just trying to explain to him like what I was doing. And when he called me, I was on hold with the non-emergency line because I've had to get 2 civil standbys and then the other tether people, they let me.
When they told you you were in the zone, why didn't you just leave
So
instead of arguing with them?
I should have, Your Honor, and I'm very sorry for that. I'm telling you, Your Honor, this would not happen again.
It shouldn't have happened this time.
I understand.
Young lady, when you left here, I know you were not happy with what the court said that you were going to get a scram tether before you saw your kids. I know you weren't because of the way that you walked out. And you have to understand how you look because some people think I'm not paying attention to what's going on. I'm paying attention to everything that's happening in this courtroom. And I saw you stomp out past the gentleman the gentleman and the woman that were here for supporting you. You just walked past them. You walked out, and then within hours of that hearing, and we had talked about, and I think it's important to point out, we had talked about how you were going to go about getting visitation with your child. You weren't happy with there was going to be a scram tether prior to that ever occurring. You walk out of here, and then next thing I know, you're in the zone, the exclusion zone. And then when I get the entirety of what I have here, people are, could be an accident, could have driven through it. But then when I get the entirety of the report, you're arguing with the people. You're arguing with them when they're telling you you're in the zone and to leave. And you don't leave. And then I think there's a reason why I don't understand why all of a sudden then all of this happens. Understand some of the underlying charges in this case. They ask you to take a PBT and you don't.
Am I able to?
I'm not saying that you could be compelled to do it. You didn't have to. Right. But if you look at what is here, I don't get why you didn't.
I think in retrospect, Your Honor, she would. I think, but she indicated at the time she was in compliance with the sober link and had blown in earlier that day,
Yes.
and so
I already did my sober link that day, Your Honor. And I explained that to her. I just didn't bring it with me when they arrested me, like my sober link that I had.
So this has been a very harsh lesson, but she has learned it.
Oh, harsh, yeah.
Overall
May I
making.
speak, Your Honor? So I'm not opposed to the scram tether. If I will prove to the court.
Oh, so, yeah, now you want the scram tether because you want out. You messed up big time. Because I'll be honest with you, when I heard the allegations, I don't know why you're out. But I figured somebody saw something that you were in compliance and maybe there'd be some, and then you do this. So young lady, you tell me why I should trust
Your Honor, I feel like that I should be trusted because, well, for one, I am starting the peer recovery program. I missed my treatment in the program Monday because I was incarcerated. I have to go on the scram tether and go back on GPS tether. I would not enter the exclusion zones anymore, ever. Because this is just my first time being in trouble. Like I have not been in trouble or have to go through like things like this before. I also have a job that I have to get back to as well. It's a really hard lesson for me, but I really feel like sitting in here, even on Mother's Day weekend, like I really have learned my lesson. And if you trust me, I will not disappoint, and I can prove to the court that I can stay sober and stay compliant. And I just ask that you would please take that into consideration, Your Honor.
What are we doing with? The case is already set for what? Prelim before me
Yes, Your Honor.
Your Honor.
this Tuesday.
On Monday, there is an interview, a child access center interview scheduled with a child victim on this case. So I don't think I'm going to have the detective order signed that interview over to prior to that preliminary exam. I just wanted to put that on the record so that that's clear.
We understand that. At this time, we'd like to keep the date and then, but understand there may be some additional, if Your Honor would allow discussion on that day. I know Ms. Yavi plans to keep this case and to be at the preliminary exam. It's going to ultimately be her case and so forth.
Defendant's bond with previous issues is reinstated. Young lady, I'm going to give you a fair warning because this case is before me. You mess up at all, I will put you back and you will stay. Am I clear? Yes. With the previous conditions, including the GPS, she will also get something else for her other leg. I want her on a scram tether.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case, People versus Sean Call.
Plug Defender Don Viliba for Mr. Call. Mr. Call, could you tell the court your name, sir?
Sean Call.
And take your name out here. Interim requesting interim. We did get an offer. I think we're likely to accept it, but I just like give Mr. Call some time to think about it.
May 28th, 2026, 9 a.m. Bond continued.
Thank you.
Court calls case People versus Amanda James.
Go for the same thing, Your Honor.
Assistant Public Defender Davi Lipo for Ms. James. Ms. James, can you tell the court your name, please?
Amanda Jones.
Thank you.
And you're requesting adjournment in this matter. We're still negotiating. I would also like to address bond, please.
Okay. I'll adjourn it to May 28, 2026.
Thank you, Your Honor.
And as to bond.
Sorry.
Did you still want me to address bond?
Yes. I'm just tired.
Your Honor, Ms. James would admit to her failure to test. What she's explained to me that her failure to test has been all of her being overwhelmed and confused between this case and a 1482 matter. She explained that she'd been in contact with the 1482 court regarding a warrant recall, which she believed would apply to this case as well. She's also indicated that she has some cognitive and memory challenges, a history of past injuries. We'd ask the court to consider a personal bond or in the alternative, a $2,000 10% bond that she indicates to me that she could post. She will test as required for release. We have no objection to a tether. She does have a part-time job as a home care assistant. She is concerned that she will lose that job if she's unable to get out. She's also concerned that she'll lose her housing if she's unable to pay her utilities.
Respond.
Your Honor, people have some concerns because we believe that this defendant had been gone for 6 months following failure to appear. Believe this is also set for or a violation hearing, if I'm not.
Yes, it is.
But ultimately, it breaks this project, but if the request modified bond, you would be able to this.
Anything else, Mr. Legal?
I would just note that we would not object to that tether request.
I don't understand why you're saying you got mixed up with another order?
Yes, Your Honor. There was a case prior to the case I was in for. The 24 case?
Okay, so where have you been?
I've been home and working. Like this, me coming in this time, someone else was I was at a friend's house, a situation occurred, and I gave my name to come in. So I haven't
failed to appear.
And I did a warrant recall. I'm sorry, I didn't mean to cut you off, but I did it for the wrong case. I wasn't even aware, but I apologize.
So why didn't you, but you've been gone for quite a number of months.
I wasn't aware that this case was this 25 was, that's the thing. I wasn't aware that this case was an active going case. I knew it was pending.
What do you mean it?
But I didn't. That was the confusion.
Your Honor, I think Ms. James may have believed that there was a pending warrant recall request. Is that what you're indicating, Ms. James?
That I did it for the wrong case. I was waiting on information. It doesn't make sense when I.
So you're saying that you knew you were supposed to be here on this case, did a warrant recall, but it was for the wrong case, and did nothing.
I knew I had a warrant. I wasn't confirmed on which case. I thought it was.
Well, how'd you come into custody on this case?
I just came in because I had a warrant. I just wanted to clear my warrant.
So you didn't know before you had a warrant?
Not for this case, no.
So how'd you find out you had a warrant for this case?
When I came in, they told me I had the FOC and I had the 0932 case. And then they said, and you had a bond violation for 20.
When you're saying they told
the officers.
The who?
The officers, when they detained me. When I was in the police car, they're like, oh, you have this case. Oh, you have this case.
Okay, so why were you in the police car?
Because where I was at a friend's house.
Okay.
For being taken for a warrant. And they asked my name. I gave my name because I knew I had a warrant. And I came in on the
warrant. Yeah, it was all clear.
Can you explain it?
Your Honor, I think what Ms. James is attempting to explain is that she was brought in on this warrant when she was visiting with a friend. The police came to arrest a friend.
Without doing everything else but taking care of this warrant. Okay. Motion. Found looking. Thank you.
Your Honor.
Courthouse case, People versus Castilian, Patton Roberson.
Does that on behalf of the people you're on?
And assistant of this. Mr.
There he is.
Mr. Cotton Robertson,
Sir, can you state your name? That's him. I can't make him out. What are we doing?
Your Honor, we need to be able to reach Mr. Cotton Robertson. Could the court have him call our office? We have a plan that we would like to put into motion, but we just haven't been able to.
I'll adjourn the matter to June 4th, 2026, 9 a.m. Sir, you need to call the public defender's office today. Hear me?
Yeah, I hear you. And the number is, I've been trying to reach out to Nicholas.
Hold on. You need to call, Mr. Cotton Robertson, you need to call them today. Make sure they have a good phone number for you and an email.
Okay.
Okay, because otherwise we're gonna have a problem.
All right.
All right? If you don't touch base with them, your next appearance on the 4th, you need to appear in person. And I'll make sure the two of you are in a room talking.
Yes, sir.
All right?
And Mr. Robertson, it may not be Nicholas who is handling your case. That's why you have to call the office and not just him, because if it's assigned to someone else, we need to be able to contact.
I understand. Can I
Call
say
me and
something?
talk about it.
They said Shanaz is supposed to be reaching out to me like 5 different times. I don't know who that is. I never heard from her. Never got an email. I don't
You
even
know who
who that
Janaza is?
No, I don't know who she is at all.
Oh, everybody knows Janaza. So if Janaza calls you, you need to answer.
Oh, my phone has a rung from Shanaz. It's rung from 2 different guys, but no female. But I understand.
Okay.
I will call the public defender's office.
Okay, just call the PD's office.
Yeah. You got the number for them?
Sure. Area code 734
2 seconds.
222 6970.
You said 6170.
6970.
All right, I appreciate you.
All right. Take care. We'll see you in a few weeks.
Thank you.
I am shocked. I thought everybody knew Chinaz. Saying. Just be the little world I'm in. Anyway, court calls case, People versus Craig Robinson.
We're on.
Assistant Public Defender, Shanaz Kimberly, on behalf of Mr. Craig Robinson, who's approaching. I think Mr. Robinson knows who I am, Judge. Come on up. Mr. Robinson, state your name for the record, please.
Craig Robinson.
Thank you.
Your Honor, we respectfully request that this matter be set for preliminary examination.
All right. Discovery is complete.
To our knowledge, Judge.
No other witnesses available to 26. Preliminary examination will be set May 26, 2026, 9 a.m. before
Judge Freshour.
Judge Freshour. Bond continue.
Thank you, Judge.
Court calls the case People versus Enrique Davis. Might be Eric. Yeah, because there's no end. Eric Davis.
Yes, I'm here.
All right.
Senior Assistant Public Defender representing Mr. Davis.
Sir, state your name.
Eric Davis.
Thank you.
At this time, we are asking for a preliminary examination.
Discovery is complete. People have their witnesses available to 26. Preliminary examination will be set in person, May 26, 2026, 9 a.m. before me. All right, sir?
All right, thank you.
Bond continues. Thank you.
Thank you.
Court calls the case of the people versus Jason Szymanski.
Your Honor, for the people.
Joy Gaines, Senior Assistant Public Defender, representing Bansky, who's approaching the podium. Your Honor, there was an offer extended that if Mr. Szymanski waives one, he could plead to one count and another count. The second count would be dismissed. Mr. Szymanski is asking for some additional time to discuss that and think about that offer. We're asking for a briefing.
During this matter out May 28th, 2026, 9 a.m. Thank you.
All right, thank you.
Court calls case people versus Twan Addison.
Morning, Your Honor, reading for the people.
Twan Addison.
Yes. I'm here, yeah.
That's me. Joy Gaines, Senior Assistant Public Defender, representing Mr. Addison.
Sir, can you state your name?
Twan Antonio Edison.
Thank you. What are we doing?
We're requesting a preliminary exam, Your Honor.
Discovery is complete.
That is my understanding.
People have their witnesses available to 26.
Court, Mr. Honor.
Preliminary examination will be set May 26, 2026, 9 a.m. before Judge.
Pressure.
All right, bond will continue. Thank you.
Thank you.
All right, thank you, Your Honor.
Thank you, sir. Court calls the case, people of the state of Michigan versus Terry Little Andre.
Both for the people.
Or Little Andre Terry.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Terry, who's in lockup.
Your name?
Little Andre Terry.
Thank you. I have before me a plea form indicating that he's going to plead to an added count 3 of retail fraud in the second degree, the 1-year offense. Upon his plea to that charge, counts 1 and 2 would be dismissed. There's sentence agreement of no restitution. That's the court's full understanding of the agreement.
Yes, Your Honor.
That is correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so?
Yeah.
State your name, please.
Little Andre Terry.
Sir, it is this court's understanding you're going to plead guilty to the charge of retail fraud in the second degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
Still wish to plead guilty?
Yes.
I should also advise you, while I'm taking your plea, I would not be your sentencing judge. You'd be sentenced before Judge Washington in the 14B district court. You understand that, sir?
Yes.
Okay. So to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
All right. You signed or had someone sign on your behalf an advice of rights form?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And of your own free will? And because you believe that you're guilty?
Yeah.
July 26, 2025, at the location of 010 Whitaker Road in Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do at the Kroger store that makes you think that you're guilty?
I took some products and stuff from there, some alcohol and some food from there.
Say again?
I took some food and alcohol from there.
Tried to walk out without paying for it?
Yes.
Store was open to the public at the time? You didn't have anybody's permission to take that property, did you?
Oh,
And was the total value of everything that you took in excess of $200? Yes?
yes.
All right. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the people or the court would no longer be obligated or bound by any sentence evaluation or recommendation. You understand that?
I do.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, thank you.
And have I complied with the court rule?
I think the court may have missed asking if the merchandise was for sale, but other than that, I'm satisfied.
I think he said he took it. Like that's a good point. The stuff that you were taking out was property that Kroger had offered for sale.
Yeah.
I'm satisfied.
Yes, I'm satisfied as well, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. The pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
June 25th at 10 a.m.
June 25th, 2026, 10 a.m. before Judge Washington. Bond.
I'm so sorry.
Go ahead.
May we address bond, please?
Can I stop you? No, go ahead. I'm just put it that way. Go ahead.
So, yes, Your Honor, Mr. Terry has some pending matters in 15th that are scheduled for sentencing May 29th. For those, by the time he is there for sentencing, he will have had 72 days in the Washtenaw County Jail. We're asking that he be granted a low cash bond or a personal recognizance bond so that on this case, and this is the last matter that he has to resolve. And at this time it is.
So he's going to 15th at the end of May.
That is correct.
Those are the last things that he has to withdraw besides this.
That is correct.
Any response from the people?
Judge, I asked him at least to get this probation interview done before he's released. He has got quite a few cases going on, so I'd like to see it evaluated at 14B. For converting to a PR or cash bond.
I'll grant the request for a reduction. I'll continue his bond as it is right now. I will grant him a $1,000 personal recognizance effective May 30th, 2026. So after he takes care of his 15th, this won't be holding him.
Thank you.
All right. Thanks. Court calls case people versus Paloney Franklin.
Morning, Your Honor. Raymond Cook for the people.
The public defender, Jazmine Morris, on behalf of Paloney Franklin.
They here?
Yes, sir.
Sure.
Oops.
Franklin, state your name for the record. Kalani Franklin.
All right. Have before me a plea form indicating she's going to plead to an added count 2 of retail fraud second degree. The 1-year offense upon her plea to that charge, count 1 would be dismissed. There is an agreement to sentencing under HIDA. That's the court's full understanding.
That's ours.
That's fair.
That's ours as well. Good.
May I have her sworn?
You solemnly affirm the testimony, the whole truth and nothing but the truth, so help you God.
Yes. Paloney Franklin?
Ma'am, it's this court's understanding you're going to plead to an added count to a retail fraud second degree. That is a misdemeanor punishable by up to 1 year incarceration. A $2,000 fine plus court cost. The fine could be increased to 3 times the value of property taken. If that's greater than $2,000, that would become the maximum fine. Do you understand that?
Yes, Your Honor.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Okay, yes, Your Honor, I understand.
Okay. Still wish to plead guilty?
Sure.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, Your Honor.
All right. You signed an advice of rights form. Is that correct?
Yes.
Any question regarding any of those rights?
No.
The paragraph 5, you have to do a copy on the podium. Those are your rights if are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, I am.
And because you believe that you are indeed guilty of this offense?
Yes, I do.
Pardon?
Yes.
Yes. On the date of December 22nd, 25, at the location of 1254 E Horse Road in Ypsilanti Township, Washtenaw County, State of Michigan, what did you do at Pet City Pets that makes you think that you're guilty?
I took a dog.
Okay. So you went in, you took a dog,
I stole a dog.
store was open to the public at the time?
Yes.
You didn't have anybody's permission to take the dog, did you?
No.
And this dog was offered for sale?
Yes.
Was the price of the dog in excess of $200?
Yes. My country.
What kind of dog was it, young lady?
A Yorkie.
I thought you said a dog.
A Yorkie.
I know, I heard what she said. Oh, okay. It was a Yorkie?
A puppy.
Yeah, but that's like this big.
Yeah.
How big is a Yorkie? What? What do I have about a Yorkie? That's not a real dog. I like big dogs. I had Yorkies, but I lost them because they're so little. They just ran off. I can't find them. That's why I get big dogs. I'm sorry. Sorry. Why'd you do that, young lady? You wanted a dog.
I did for my daughter.
How old's your daughter?
She's 2. She'll be 3 on May 23rd. Someone recently before that stole,
Pardon?
someone recently before that stole my daughter's Yorkie.
I know, you guys are gonna do something better than this. I'm not gonna accept the plea.
Okay,
I'm gonna adjourn this out 2 weeks. You guys figure something else out.
Judge.
Probable cause conference, May 28th, 2026, 9 AM. And I'm just gonna let you know that if what she's telling me is correct, I mean, certainly people can do wrong, but I don't know that she should face 1 year incarceration for that. Thank you. We'll see you in a couple of weeks. Bond, continue.
Thank you.
You're welcome. Court calls the case, People versus Ashley Treat.
Mr. Feltus for the people.
Troy Gaines, Senior Assistant Public Defender representing Ms. Reed. And would you please state your name for the record, ma'am? Ashley Reed. And just so your honor is aware, she does have her mother here for moral support.
Pardon?
Her mom is here for moral support. This time, we are asking to adjourn the PCC, but to address bond violation. In terms of the bond violation, at this time, my client wishes to vet. She indicates that she did in fact relapse, that and that she has been in custody now since a week ago today. And so we're asking that the court consider taking her and sentencing her to time served for the bond violation. Because, as I don't know if the court is aware or remembers, she knew that she had relapsed. She had gone through her insurance to Henry Ford Hospital in Jackson, who at the time was recommending outpatient treatment. She did explain to them that because of the relapse, that she may, in fact, have to be incarcerated. They indicated that they would still be able to have a place for her upon her release, and that if necessary, they could get her into inpatient treatment. Again, this is through her insurance, so we're asking if the court would consider releasing her with credit for the days served, reinstating her bond, placing her, if deemed appropriate, on scram tether, and allowing her to go into treatment through her insurance, and provide, if the court wanted her to provide documentation of that appointment by Wednesday so that she could get that in, to your honor, she'd be able to do that. I'm sorry.
I have a couple of concerns. Certainly there's the violation of the bond condition, but just the judgment of having a child blow into the sober line. I don't know, and I understand what you're saying regarding some of that, but that's a messed up judgment. That's the only way I can, messed up being a legal term. I don't even know how you get there.
I think you saw her nodding her head in agreement that that was messed up judgment. There are, I want to be careful with my words just because I'm not sure who all may have access, but there are other extenuating, triggering circumstances in the household as related to her personal relationship.
Okay.
And she, that were part of the relapse and the triggering for that. And she is trying to get out of that situation. She has a license in medical billing. She's worked in that field before, actually over 20 years in that field. And she had just started a new job, a better job that she hopes will position her to be out of the situation that is triggering. And they are holding it for her right now. They were aware that she had this case pending.
All right, respond.
Your Honor, last time that we were here, the people expressed their extreme concerns over the defendant's behavior. I understand she's admitting to having a relapse. I'm not sure if she's going to admit having the child blow into the silver link. I do think it's worth noting, and I would like the court to just have it in its mind that her silver link flow was a 0.083. So this wasn't as though we had one drink or two drinks. This is drinking. And it's of concern to the people that was the point that we got to. I believe last week we discussed that she had been approved for intensive outpatient. And I don't recall what Ms. Gaines said on the record a few moments ago, and I apologize if it was going to be inpatient or outpatient, but this does, in my non-medical opinion, screen for inpatient. The history of what I've seen. The concern of the people is I don't know much about the Henry Ford thing, and I would like to learn more before I make the agreements. So at this point, I'm not agreeing to the request for release to treatment, but I will leave it in the court's discretion. And I hope that the court will address any further questions it has of me or anything else.
And I know that my client wishes to speak so that you can hear from her. I did just want to clarify my words that I'm focusing on the relapse because there would not have been any engagement of the child absent that is the whole, that the alcohol issue is the whole issue. And by relapse, I was not at all saying that she had had one beer. That is not what she had had half a glass of wine. I was not trying to imply that by using that word.
And then people don't think that Ms. Gaines is trying to mention. So
yeah. So she's and she is not minimizing that. She is a single parent. And she has not been in any trouble for 12 years. So she is really hoping to turn this around so she can get back on the track she was before being in this relationship that has triggered all of these, the relapse.
What do you want to tell me, ma'am?
I just want to apologize to you and your court. I'm sorry that I disrespected and embarrassed you. I probably don't deserve a second chance. But I need to prove not only to you and the court, my family, my kids, but myself. I was clean for 9.5 years. This domestic violence case in this relationship, I was diagnosed with borderline personality disorder. I don't know if you know, but it's been a struggle. And I've really focused on that. And I knew as soon as I got triggered by him again, I ran to get help. And I just hope you give me a second chance to prove to you that this is not me. Outside of here, Judge, I coach my kid's middle school softball team. She's in travel ball. She's in travel volleyball. I volunteer at her school. I'm supposed to go on a Mackinac Island trip on the bus with her 8th grade class. Like, I'm not a bad person. It's some messed up choices lately. Drugs are not the answer. And I know that. I was clean for 9.5 years. Sorry, I didn't just. I'm sorry.
I'll adjourn probable cause to June 4th, 2026, 9 a.m. Defendant having admitted to the violation, I'm going to sentence the defendant to 10 days. Credit 8. Defendant is to serve that balance of those 2 days. Prior to her release, defendant must be placed on a scram tether prior to. Then her bond previously will be.
Thank you.
Thank you, Your Honor.
June 4th,
Yes. Court calls case People versus Corey Folk.
What is Judge Marshall Feaster, Assistant Public Defender, on behalf of Mr. Falk, who is approaching the podium. Mr. Falk, please state your name for the record. Thank you, Judge. Just speak to Mr. Falk. We are working to find a resolution on this case. We just need a brief adjournment and try to get this wrapped up.
Oh, really? Yeah, come on. Our record should reflect, been a bench conference in this case. The discovery is complete. The people, if they're going to have their witnesses, would be available on the 26th. Court's going to set this matter for preliminary examination. May 26th, 2026, 9 a.m. That's before me. Bond will continue.
Okay. Thank you, Judge.
Thank you. Court calls case People versus Kyle Zimmerman.
Very again, Judge Marshall Feaster, Assistant Public Defender, on behalf of Mr. Kyle Zimmerman, who I'm hoping to hear someone. Oh, here we go.
Oh, this person here.
Please state your name for the record.
Kyle Zimmerman. All right.
Judge, I did tender a mitigation report, Miss Lonnie Feltons, and we asked for a brief adjournment for her to review as we can try and get this matter resolved.
May 28th, 2026, 9 a.m. Bond continue.
That's it.
All right. Thank you.
What's the date?
Court calls the case People versus Stephen Javon.
Stephanie Cannon on behalf of Mr. Given, Your Honor. And
because of you, he's refusing.
yeah, no, I was going to tell the court that, yes, because of me, he is refusing. I'm just asking for an adjournment. It's my understanding as of yet he is not competent. Last time I checked, last report we had says he is not competent at this time.
So I'll adjourn the competency hearing to. Well, we won't get another report. Well, this is adjourned to June 25th,
Thank you so much, Your Honor.
2026, 9 a.m. Court calls case People versus Jordan Harris.
Right here, Your Honor.
Stephanie Cannon on behalf of Jordan Harris, who is appearing by Zoom.
Yes.
Ms. Harris, could you state your name for the record, please?
Jordan Harris.
Thank you.
Your Honor, we're asking that this case be set for preliminary.
Discovery is complete.
To my knowledge,
We'll have their witnesses available to 26.
Do your best, Your Honor.
Preliminary examination will be set for May 26, 2026, 9 a.m. before Judge Freshour. Bond will continue.
thank you so much, Your Honor.
The court calls case Field versus Robert Harris.
That's about this people.
Assistant Defender on behalf of Mr. Robert Harris, who is approaching the podium. Please state your name for the record, sir.
Robert Harris.
Thank you, Judge. I have spoken to Mr. Bellinger on this file. Sounds like he's working on a resolution that includes something at circuit court. If we could adjourn that for 2 weeks, I think he'll hopefully have an answer from the prosecutor at circuit court and get this matter resolved.
During this matter without objection, May 28, 2026, 9 a.m. Bond continued.
Thank you. All right, Mr. Harris. 2 weeks.
Court calls case People versus Daniel Heelan.
Judge Torshov, both defender of Mr. Heelan, who's appearing by Zoom. Mr. Heelan, would you?
Mr.
And state your name for the record once you're unmuted, please.
Please turn via Zoom.
Looks like he has permission, the dots on the docket, Judge.
Where it was revoked
Okay.
because he had a violation.
Okay, I apologize. I was unaware of the revocation.
Local.
I believe so, Judge. I think I can explain the violation also if the court would allow.
Well, I want him here. Then maybe I'll listen to it.
Okay, Judge.
Here this afternoon.
He's indigent, Your Honor. I don't know if he.
Pardon?
Indigent. I don't know if he has resources to be able to get here this afternoon. I'd have to ask if he could appear. My understanding is he was just released about a month ago from Bear River for a 90-day program. And now he's doing out.
And adjourn the probable cause conference to next week. To the 21st.
We'll need you here in person then, Mr. Heelan.
Yes, sir.
To May 21st, 2026, 9 a.m. in person.
Thank you, Judge.
Bond at this time will continue. Thank you. Court calls cases of the People versus Douglas Hill.
Stephanie Cannon on behalf of Mr. Hill. Mr. Hill, could you please state your name for the record?
Douglas Hill. You're requesting an adjournment.
Yes, Your Honor.
Matters are adjourned to June 4th, 2026, 9 a.m. Bond continue. Thank you.
Thank you.
Versus Eric Jackson.
Ashley Feltus for the people.
Right. Ready, Judge. Torshov Feaster, Assistant Public Defender on behalf of Mr. Jackson. Please state your name for the record.
Eric Jackson. Sorry.
Well, we are requesting a 2-week adjournment in this file. It sounds like Mr. Jackson spoke to our interns and asking me to do a mitigation letter for the prosecutor office. So 2 or 3 weeks, please.
May 28th, 2026, 9 a.m.
Thank you.
Court calls case People versus Brendan Lathrop. No. Even more so, no. I don't know that.
Officer of the court, Judge. It's the
Yes, Your Honor. Mr. Lathrop works 2 jobs, is that right? And he go out in the hallway, he tired and he did not want to disrupt people around him. So he is.
Your name?
Brendan Lathrop.
All right, what are we doing?
Your Honor, we are requesting an adjournment. We are an ongoing negotiation and not too long before Mr. Lathrop's case was called, received some additional information from the prosecutor.
2026, 9 a.m. bond continued. Thank you.
Sir.
Thank you.
Court calls case people versus Caleb Martin.
You're bringing up the people.
Stephanie Can on behalf of Mr. Martin.
That was a stall.
I didn't see him. Your Honor, we're just asking for this case to be set for preliminary exam.
Discovery is complete.
To the best of my knowledge.
People have their witnesses available to 26.
Sure, best son.
Preliminary examination, May 26, 2026, 9 a.m. before me. Bond continued. Thank you. Court calls the case people versus Eric Mayfield.
Thank you. Appreciate it. Appreciate it.
Is my
Who?
Mr. Feast.
Ready, Judge. Portia Feaster, Assistant Public Defender on behalf of Mr. Mayfield. Mr.
Mayfield, state your name, please.
Eric Mayfield.
Thanks.
I will prepare a green sheet on this one, Judge. It looks like we do have an offer on this matter to resolve it. We just need 1 or 2 weeks to get the paperwork completed.
June 4th, 2026, 9 a.m. bond continued.
Thank you, Judge.
Thank you, Mr. Mayfield. Court calls the case people versus Desmond McCaster.
People.
Cannon.
Stephanie Cannon on behalf of Mr. McCaster.
Your name, sir?
Desmond McCaster.
Thank you. Where are you going now?
We're just asking for a brief adjournment in this matter. And I want to run it past the prosecutor to see if that will work with them.
Boy. I don't know what that meant, but good luck to everybody. June 4th, 2026, 9 a.m. bond continued.
June 4th. Thank you, Your Honor.
Thank you, sir.
Thank you.
Court calls the case people versus Don Mitchell.
Miss Mitchell. State the name for the record.
Dawn Marie Mitchell.
Thank you.
You're welcome. Thank you, Your Honor. Good morning.
I apologize.
Come on. To you that you don't patients that are there can be read to be an attempt by you and the victim to manipulate this process.
It wasn't even about that.
Well, I'm going to suggest that you don't say anything because that's the way it certainly could appear based upon that. Which you should have realized could lead to additional charges for you. So I'm going to suggest that you and the alleged victim in this case, I'm not going to remove the no contact. I should, but I'm not going to because it was given by the magistrate. But I'm going to suggest to you that you don't talk about it anymore because you're going to end up in greater trouble than what you got now.
So don't talk about the case. You understand that?
Yeah.
Okay.
I got my word. Got my word. Thank you, Your Honor.
I'll adjourn it out to the June 4th, 2026 at 9 a.m. Bond at this time will continue with that admonition to
All right. God bless. Have a good day.
you.
Wait in the hallway out.
And I'll talk to somebody about that. So, court does call the case, People versus Maurice Robinson.
And Assistant Public Defender, can I be carried out to root, Your Honor, on behalf of Mr. Maurice Robinson, but not with.
Judge, we were informed that Mr. Robinson was released from our jail, and I believe he was picked up by Winnebago County. That's in Illinois.
I know that.
So I did not.
Try to say Winnebago County here.
Is there one here?
No.
Oh, okay.
She just saw an RV and she said, "Oh, that's a county outfit." Go ahead.
I did. I thought it was up north, Judge. I don't know where that is. So we've informed the people, so they're going to work on getting a writ to have him here, but we have not had contact with him. That's just all we've been able to.
But do we know he's in Winnebago County?
I believe so. I know
That's really a no.
From a PD who was representing him on another case, and that's what she stated, that she found out that
Just waiting on the files. Ringo Silva. And it's
The Lavity Junior, 26F246141. All right, your name, sir?
Green Lavity Junior.
You're charged with operating while intoxicated. You have the right to an attorney. Would you like one?
Yes.
Okay. You go out in the hallway, we'll set you up with a court-appointed lawyer, okay?
Okay.
And then either way, after you speak to your lawyer, he or she will speak to the prosecutor and you'll come back and in front of me, all right?
Okay, thanks.
All right, good luck.
Good.
Which file?
Judge.
Oh, which one?
It's probably a overweight, right? Some civil infraction?
No registration.
What's the last name?
Seth Cat.
Right here.
Okay, I'll take that.
I already spoke to Ron.
Okay, people against Ali Sefkat, 26F246171.
Paulie, no time to have Mr. Sefcat. Your Honor, will you waive his presence? He's allowed to appear by way of Zoom. He can.
Just make sure in the future that they're here. They're reducing this to the civil infraction, but on a misdemeanor, he still has to be here, okay?
Understood.
Does he stand mute? That's all right. Does he stand mute, waive formal rating?
Yes.
And now you're going to plead to, on his behalf, expired plate, which is of course a civil infraction. They're going to dismiss the driving an unregistered vehicle, correct?
Yes.
To that charge on his behalf, expired plate, responsible or not responsible?
Responsible.
Okay, this was a commercial vehicle, correct?
No, it was not. It's a logistics company. They
All right.
ordered around,
150, and I'll give them until May the 21st to pay, okay?
You said 150?
Yep.
Great, Judge.
Have a great day. Thank you.
Good seeing you.
All right, you too. Kristen Marie Sauve, 26F245718, and B and C. Good morning.
Good morning.
Good morning, Your Honor. James Britton, P75873, appearing on behalf of the defendant, Kristen Silva, who's standing to my right.
Ma'am, your name?
Kristen Silva.
Good morning to you both. So she pled guilty to operating while impaired. The prosecutor dismissed the OWI, the open intox, and the speeding, and she was referred for a screening and assessment. Have you had a chance to review the report with her, and are there any material additions, corrections, or deletions?
There are, on Your Honor, if I had the opportunity to review it with my client, she agrees there are no additions, corrections, or deletions.
Okay, anything that you would like to say on her behalf?
Yes, Your Honor. We would ask just that the court take into consideration the totality of the circumstances here and the defendant that we have before us. She has no prior history, no criminal or traffic history. The police report indicates that she was cooperative. She showed minor signs of impairment. She had negative HGM tests. She's able to walk to the stand, but she did show some signs of impairment, including a 0.10 and a 0.103 on her data master. Despite those readings, there was no allegations of dangerous driving. There was no accident. There was no injury. This was just a stop related to speed. She did have a probation screening. Probation found that she had no history of alcohol abuse treatment and drug abuse treatment, no history of illicit drug use. She's got no history of blackouts, violence, or depression related to alcohol use. The recommendation was limited to education, community service, and victims impact panel, which we believe to be appropriate. This circumstance that we find ourselves here on today is very inconsistent with this defendant's life. She has been steadily employed for decades. She has worked for most of that time as a nurse, assisting people in our community. For the last several years, she's been working with the Veterans Administration as a registered nurse in their cardiac unit. She has 4 children and is married. 2 of those children have served with the country through the, I believe it was the Air Force. One is actually still on active duty right now. She does accept responsibility and understands how serious this incident was and how serious it could have been. It's already shown to have a profound impact on her life and could have employment ramifications as well. But for those reasons, I believe she clearly understands how serious this is. I believe she's very, very unlikely, more so than most of my clients, not to be back here again. For those reasons, we would ask the court to follow the recommendation of probation, to limit the sentencing to focus primarily on the education and rehabilitation rather than punitive conditions, beyond, of course, what's necessary to ensure that this defendant doesn't show up here again.
Anything you'd like to say, ma'am?
If you take accountability for my actions, I have done greatly and I'll never be back in this situation.
All right, you're 47. You've never had a prior. You had a relatively low, I mean, it's in excess of the legal limit, but you had 0.10 and 0.103, and you scored in category 1 on the alcohol and drug use portion, which tells us you have no problem. And there's a presumption that you not be placed on probation pursuant to statute. And I'm not going to place you on probation. If there was ever a case that I thought somebody didn't deserve it, based on what the law is, and it's not the law that I wrote, but nonetheless, 300 fines, 300 costs, 75 victims' rights, $50 justice assessment, 6 1/4. Screening fees, 60 for 685. I'm sorry, 785. And then you have cost of recovery, 150, 935, 3 days jail, credit 1, serve 2. I'll let you serve those by way of community service. And you have to have your community service of 16 hours completed by June the 30. Attend the victims impact panel, or 93 days if you violate. So as long as you do those 2 things, you'll be done with the case. And the sooner the better. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that, ma'am? Does she have all this to pay or does she need time?
I can pay to the
Okay, so you pay now. Probation will meet with her and you'll go from there. I sincerely wish you well. Good to have you here, Mr. Britton.
Good to see you.
Take care. You too. Thanks a lot. Good luck, ma'am.
Thank you.
All right, Castro, people against Jose. Felix Aaron Castro, 19F231230. Good morning, sir. Your name?
Morning, Your Honor. Jose Felix Aaron Castro.
All right. Okay, it looks like you did everything, Mr. Castro. Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you give in these proceedings be the whole truth so help you God.
Yes, sir.
You pled the disorder, you can put your hand down. You pled a disorderly person on February 5th under section 771.1. Since that date, have you been arrested?
No, sir.
Any new charges pending against you?
No, sir, not at all.
Any contact with the police since February 5th of this year?
Sir.
I'm sorry?
No, sir.
All right, everything appears in order. Probation says you're compliant. Balance 0. Community service hours completed. Prosecutor moves to dismiss. Congratulations, you're compliant with the terms of section 771.1. I'm going to dismiss your case. We will send you the paperwork and you are all set. Any questions?
No, Your Honor. Thank you very much.
Have a great day. Good luck. Thank you. What's your name, ma'am?
Waiting on her file. She said she was supposed to be here yesterday, didn't show up.
When did she show up?
I had court, I had court in Southgate yesterday.
You're hitting all the courts, huh? Got to show up, young lady. You got to show up, young lady.
It was at the same time, you were on the same time.
Is somebody pulling the file?
You talked to somebody down there, right?
Yes, I did.
Yeah, they gotta bring it down.
They told me that my file should still be in.
Oh, it could be. I didn't think I put the warrants down yesterday.
The bottom.
What was your last name?
McNally Wilson.
Wilson?
Yeah.
Come on up here, ma'am. Jordan Elizabeth McLilly Wilson, 267-842-380 A and B. You missed the sentencing. Your name?
My name is Jordan.
Did you bother to tell anybody that you weren't going to be here?
No, sir, because it was a mistake when I came here the last time. I already knew that I had that court date for Southgate on the 13th. I had mistakenly thought that your court date was for the 14th. So I thought everything was gonna play out okay.
You gotta be more diligent about this. We'll reschedule it this time, Heather.
We
27.
can move that to the 27th.
At 8:30, don't miss. Go down the hall, get your notice, okay?
Sir,
All right.
at 8:30 down.
May 27th, 8:30, go down the hall, right down to the cashier, and they'll give you your paper notice. Don't be late.
Start Eagle down. Yeah. Okay. That must be. Well. You look your name before. Yeah. They need to be the right.
Jim, you ever meet my wife, Kelly?
Jim, how?
Hi, Joe. Joe, Kelly.
This is my granddaughter.
Oh.
Say hi to Mr. Cohen.
Hi.
How you doing?
Judging training up there? Or? Yeah.
She's the one I'm gonna have make the decision if I get stuck today.
Yeah, sure. Well, is she broke? Yeah, I'll send her that. I know. Well, next time I thought of me, oh, yeah. Thank you.
Anything else, Freddie, or not? Well, we can go in for a couple minutes. Let's see what Mr. Ogletree has.
He's got a pre-form. I'm putting him in with the Flat Rock prosecutor right now.
We'll go out. If you can call the chambers when we're ready with something, Heather, appreciate it.
I
Thank
sure
The file from him.
Name?
Yes.
Okay. People against John, Freddy Orango, Canonis, 26F, 245, 835, A. And that's it. All right. Good morning.
Peter Bernard, P78413, MIDC counsel for Mr. Orango.
All right. Ms. Villarreal, your name?
Yes, Your Honor, Evelyn Villarreal, certified court interpreter,
All right.
C3 agent.
All right. Raise your right hand, please. You solemnly swear or affirm that you'll make a true and accurate translation between the court and the defendant and Mr. Granado.
Yes, I do.
All right. Sir, can you tell me your name, please?
Oh,
John Freddy Orango.
John Freddy Orango.
Your client pled guilty to the charge of operating while impaired. That was back on April the 30th. He was referred for a screening and assessment. The OWI, drive while unlicensed, and disregard a traffic excuse me, for avoiding a traffic control device were all dismissed.
Yes, sir.
All right. Have you had a chance to review the report with your client? And are there any material additions, corrections, or deletions?
I did, and others.
Anything that you would like to say on his behalf?
Yes, Your Honor. Mr. Orango is self-employed. He's been doing landscaping work ever since he came to the country from Colombia about 2.5 years ago. He also does metal collection, for scrap metal. He's been doing that as well, and he is the sole provider for his family. He has a 16-year-old boy and a 12-year-old boy. He's married. He's currently disabled because of an accident where he actually amputated one of his fingers at the first knuckle and severely injured one of the other fingers. So he is unable to work, do the type of landscaping work that he would normally do until he recovers. He would ask the court to consider that as far as the timing of the fines that he must pay, because he needs to recover before he can go back to work. I believe that Mr. Orango was deeply remorseful for what happened. I believe this was a one-off situation, is not symptomatic of Mr. Orango, and we would also like the court to consider that. Also, Mr. Orango would like to actually address the court about his background and what got him to this country and what the kind of troubles that he's going through.
Okay. Anything you would like to say, sir?
Bien, señor, algo que usted le gustaría decir.
Señor juez, Dios lo bendiga.
Yes, Your Honor, may God bless you.
Cristiano que soy, con mi esposa, mi familia, Gustavo Masolini, su familia.
I'm Christian, so is my wife, my family, and we have been praying for you and your family.
Y pues, de verdad yo pienso que hice, que hay un montón.
And truthfully, I'm so sorry for what I did, because I'm not someone who really drinks.
La verdad yo vine a este país, no para hablar, vine a sacar a mi
And I didn't come to this country to be a drunkard. I came to this country so that my family would be able to do better. Because over there in my country, a band of guerrillas killed my mother and two brothers.
The what?
A band of guerrillas killed my mother and my two brothers, and I had to escape the country.
Por eso estoy aquí, mi casa fue conocida por la ONU.
And that's why I'm here.
Y tengo un niño también que sufre de eso.
And I have a 16-year-old son that is an epileptic.
Y yo le pido a la verdad que
Quite honestly, I ask forgiveness for having been drinking that day. It's not something that I normally do. We attend a Christian church.
le pido de favor que si me van a dar trabajo, con mi pasaporte, para que me permita trabajar.
And I ask please that if you're going to sentence me to community service, that you allow me to do it through my church by contacting my pastor.
Okay.
So forgive me and to please take into consideration the condition that my health is in and what I'm going through right now. And thank you very much.
I'm gonna place you on probation for 9 months. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number,
Si usted cambia de dirección, de número de teléfono o del lugar donde usted trabaja,
you do have to notify the probation department.
usted tiene que notificar al Departamento de Libertad Condicional de Libertad.
No alcohol.
No se permite que usted se alcohol.
You cannot purchase, possess, or consume alcohol, marijuana, or illegal controlled substances.
Usted no puede ni comprar, ni estar en posesión, ni usar alcohol, ni marihuana, ni alguna sustancia ilegal.
Kratom, poppy seeds, and CBD oils are prohibited.
Y tampoco se permite que usted use algún
If-
crema, no
if you-
sino que tenga.
If you consume food or other items containing those substances, it will be deemed a violation.
Así que si usted consume o utiliza alguna de esas cremas o algo de bebida que contiene algo de droga, se considera una violación.
I'm in order that you submit to chemical testing, PBTs, and ETGs monthly or more on demand of probation.
Así que voy a ordenar que estar sujeto a pruebas para el uso de alcohol que sean de aliento o de sangre una vez al mes. Tal como se lo pide el Departamento de Libertad.
In order that you attend a level 1 alcohol education program.
Y también voy a ordenar que usted tenga que asistir el programa de educación de alcohol nivel 1
With the Victims Impact Panel.
y que también se participe en el panel de impacto de víctimas.
I'm going to order 4 days jail with credit for 1, but I'll let you serve the 3 by way of community service.
Voy a ordenar 4 días en la cárcel. Le voy a dar crédito por un día. Los otros 3 días voy a permitir que usted los sirva haciendo servicio comunitario.
That has to be completed by July 20.
Y usted necesita haber cumplido ese trabajo para el 20 de julio a lo más tardar.
Pay fines 300,
350.
cost 250, 75 victims' rights fee, $50 justice assessment. So that amounts to $675. There's a $60 screening fee for $735.
Y que llevamos un otro
Probation fees are $180 for $915.
por cosas.
There's attorney fees of $40 for $955. And your cost of recovery is $225, bringing your total to $1,180. If you violate probation, your probation could be revoked and you could be incarcerated for 93 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer.
Your Honor, if I may.
Hang on one second. I'm going to ask you to approach Mr. Granada, Sadie, and I'm going to ask you to continue attending AANA 1 time per week until you were in the level 1 alcohol education program. You understand all that, sir?
Yes, I got it.
Then you may be eligible for early discharge. You do everything. In 4.5 months, you're eligible for early discharge by filing a petition. And again, you have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that?
Yes,
Okay.
Your Honor,
but I'm
based
not
on,
going to appeal.
Okay.
based on his injury, I would ask the court if he could delay the starting of his payment plan until his hand recovers to the point where he can go back to work.
I'll just save $50 per week and I'll start that. I don't know how long it's going to take, but I'll just start it on August the 7th.
Perfect. That's perfect.
Okay? And if you don't have the money, no problem. Call the court. We'll go on Zoom or come up here. I'll give you an extension, okay? Do you understand all that? Do you have any questions?
seguiré morando con su familia y por todas las fuertes autoridades de este país.
Well, just thank you very much, and I will continue to pray, not just for this court, but all people in authority in this country.
Good luck, sir. Thank you very much.
And I ask you to forgive me for everything.
You're fine. Good luck.
Thank you, Your Honor. Have a good day.
Thank you. You too. Thanks so much, Ms. Villarreal. Gustavo Ruben Masolini. This is 26F 265-769. Do I have any one of the victims here? Do I have any one of the victims here? Charlene Lindsay was one of the victims. Is she here by chance? And also Vanessa Messenger. Okay. Defendant pled guilty under section 771.1 to the charge of window peeping, and he was referred for a pre-sentence report. Your name, sir?
Gustavo Masolini.
All right, Mr. Granada, your appearance again?
Peter Granado, P78413. I'm an easy counsel for Mr. Muslim.
So the agreement was that the plea be taken under the provisions of section 771.1. Have you had a chance to review the report with your client? And are there any material additions, corrections, or deletions?
Yes, I did review it. No additions, subtractions, or corrections.
Anything you would like to say on his behalf?
Yes, sir. I did get a chance to talk to Mr. Masolini, and just to tell us something about him. He has actually been doing manufacturing of RV components. He helps troubleshoot. So when people call in with issues related to their RVs, he helps them through those problems. He's been doing that for about 3 years. He has a high school diploma from Harrison High School in Harrison, New Jersey. He is single, one child, 17-year-old, who has weekend custody. He is renting right now in Flat Rock, but he is moving, I believe, to a new place in Trenton that will remove him from immediate proximity of the complainants in this case. And we would ask the court to consider that prior to sentencing.
Sir, anything you would like to say before I sentence you?
That's right. One last thing, Your Honor.
Sure.
Mr. Masolini has no criminal history.
Okay. Anything you would like to say, sir?
Because I was it's normal locked and I had a lapse of judgment, which is why I did what I did. I was trying to find them. I wasn't thinking at that time. But I mean, throughout my life, I mean, I haven't done anything. I usually try to, keep my life out of the law.
So I read that. So you're telling me you were looking in these windows because you were looking for the kids that were throwing things at you?
Yeah. I wasn't thinking I was angry, and it's not the first incident that happened in those apartments, but getting from the complex next over.
You just can't be peering into people's windows.
No, I understand that.
You're telling me you were doing that only to try to find these kids?
I thought they went into one of those apartments. Then I mean, I'm not saying I didn't do anything wrong. No, I was angry at the time. It was a lapse of judgment.
12 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. You're not to enter or go near 24805 Mayfair in Flat Rock. You're not to enter 24805 Mayfair in the city of Flat Rock. You are not to enter the property address or go near 24801 Flat Rock. Mayfair in Flat Rock. You're not to have any contact with Charlene Lindsay or Vanessa Messenger. You cannot write, phone, see, text, email them, or phone them, or have anybody else do any of those things for you or on your behalf. So no contact with the victims, not to go near those residents' addresses. You're to serve 2 days on the court work program and pay $35 a day for that, for a total of 70. They fines 100, costs 50, 75 victims' rights, $50 justice assessment. Your total there amounts to $275 plus a screening fee of $60 for $335, probation fees of $240 for $575, your court work program fees, and $40 in attorney fees amount to $685. I'm going to take you at your word. You can't be peering into people's windows, though. $685. You pay that, you stay out of trouble. You come back for your review hearing date. Prosecutor offered this under 771. If you are compliant, the case will be dismissed on motion of the prosecutor. Heather, do you have a review hearing date for me?
That will be May 13th of 27.
May 13th of 27. Okay, sir. At 8:30 in the morning. You may be eligible for early discharge, but you would have to get with the prosecutor and make sure that he's still willing to dismiss that. They typically are. So after 6 months, you may be eligible for early discharge. Your lawyer will explain that. Don't come back here, okay? Do you have all this to pay? Okay, so you can go down the hall, pay that, and then you'll meet with the probation department, okay? Any questions?
Change of, since I'm moving tomorrow, do I give the?
You notify probation of that change of address when you go talk to them. You're gonna meet with them this morning, okay? All right, best of luck. Go down the hall, get your review hearing date, your payment, and then go over to probation where you'll speak with them, all right? Best of luck. Who do you guys have over there, gentlemen and ladies?
We don't have anyone. We're reaching out on behalf of Makovich. Is Macunovich. He has a judgment of sentence here, and at the top part it says to serve 20 days with 13 days credit, but here at the bottom is to say serve 93 days in jail for failure to pay on time. I tried to call over so I didn't have to zoom in, but I'm trying to figure out what are we doing with his judgment of sentence. Is he to do the 93 days or is he only to do the 7 days? Because it's due for releases technically today.
Okay, can you just bear with us a second? Heather, will you please check into that Macunovich case?
Yes, and I also thought, was this the one that I thought Beth reached out and said you wanted to speak with him? I thought this was the one.
No,
Am I
it was
wrong?
on,
Or is
it
this
was-
the wrong one?
no, this wasn't on Macunovich, it was on Mulhern.
Oh, Mulhern, okay. Let me check on Macunovich then.
They'll check real quick, okay? I promise you we won't keep you waiting, all right?
All right, thank you.
Thanks a lot. Ael Barrera, 26R514633. Morning. Your name? Did you just meet the prosecutor on your own?
Yeah.
So you went and spoke to him and you don't wish to have a lawyer?
Yes.
Am I right?
Yes.
So you're waiving formal reading of this, driving on a suspended, is that true? And now you met with the prosecutor and you negotiated a good deal for yourself, or you're going to plead guilty to allowing an unlicensed driver to drive, and you're going to then have them dismiss the driving on a suspended, true? If you do that, the possible penalties on this are up to 500 fines, 90 days jail costs, or all those 0 points though. You understand that?
Yes, sir.
And you just signed, read, and understand and advice of rights form here today.
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that? All right, so I'll tell you again, you have the right to a lawyer. If you want one, I'll give you one. You want a lawyer? To the charge, allowing an unlicensed driver to drive, how do you plead? Were you on April 3 of 26 in control of a motor vehicle that was being operated on Huron River Drive near Stryker in Rockwood at 8:52 p.m.?
Yes, sir.
And you allowed somebody to drive that 2012 Kia that was suspended, revoked, or denied. Is that true?
Yeah.
And that was you, correct? And are you on probation or parole? Anybody forced you to plead guilty?
No.
Please accept. The suspend's dismissed. You're still suspended though, right?
Yes, sir.
When are you going to get around to getting a valid license?
It's definitely gonna take me a while, but
trying to get the process going. I have a payment plan going on a year or more. So that I'll probably about 1,500 in. To pay still, so that's probably gonna take me a while. But I'm definitely not gonna do something I need. I have to get back and forth to work every day. And right now it's really killing because I have to take Uber and I have to take gas money and it's really like it. But so
All right,
I'm doing my best to get everything paid off so I can look at my lessons.
good enough. Fines 100, costs 125, 75 victims' rights, $50 justice assessment. 350 or 90,
Sir,
I'm sorry, 350 or 60 days. Do you have all that to pay?
I'm sorry.
350 or 60 days.
350.
You can pay that now? All right, you're all set. Go down the hall, take care of that. You're all set. I wish you well. Good luck. Thank you. Good luck. Nicholas Carlson. You go against Nicholas Scott Carlton, 26R514665. Your name, sir?
Nicholas Carlson.
All right, so you're going to plead impeding traffic, true?
Correct.
To that charge, responsible or not responsible?
Responsible.
All right, 150 is your total. I'll dismiss the distracted. You can go down the hall and make your payment. You're all set.
Thank you.
Best of luck. You too. Thank you. People against Felicia Patton. People against Felicia. Tomorrow, Patton, 26R514616. And could I have seated at the table up here? Allwell, please. Right over there at that table. Ma'am, step up to the podium, state your name.
Morning, Felicia Patton.
Good morning to you. You're going to plead impeding. You're going to dismiss the speeding, true?
Yes.
To that charge of impeding, responsible or not responsible?
Responsible.
And I'll accept the plea, dismiss the speed, 150 down the hall, pay your money. You're all set. Good luck.
Thank you.
Allwell. Yes. Come on up to the podium. People against Gryphon Joseph Allwell, 26R514671. I'd like Swanson seated at that table now. Your name, sir?
Griffin Olive.
All right, you're going to plead responsible to impeding traffic, true?
Correct.
You're going to dismiss the improper pass, true?
So yes,
To that charge of impeding, how do you plead, responsible or not responsible?
responsible.
All right, I'm going to accept the plea. You got one prior, 160 is your total. The improper pass is dismissed. You can go down the hall, pay that, and you're all set. Good luck.
Thank you. God bless.
You too. Thank you. Matthew Swanson, 26R514615. All right. How you doing?
You're good, yourself?
Good. Your name?
Matthew Swanson.
All right. So you are charged with speeding, and you're going to plead to impeding, right?
Yes,
Responsible or not responsible to that?
responsible here.
You're all set. Original charge dismissed, 150. And you go down the hall and take care of that, and you're all set. Good luck.
Thank you.
Thank you. Hi, Lieutenant. David Singh, 26R514608. He did not show up. He is responsible as charged by default. Responsible as charged by default. People against George Rosca, 26F246016. Is Mr. Ogletree out there?
Good morning,
There he is.
Good
Good morning,
to see you.
Good morning, Mr. Ogletree. How are you?
I'm doing okay. Just on the way to a conference. Sorry about that. I have authority to settle on behalf of my client. My understanding offer is CMV impeding is the reduction. He accepts the offer.
Can you start your video for me, please? All right, there you are. You're not in a car. Come on. You're not moving in a car. You wouldn't do that, Mr. Ogletree.
I'm in
Pull
the
over.
back seat. I'm not the
Pull
driver.
over. I'm not handling cases with kids. They're people in moving motor vehicles. You're gonna have to pull over.
All right, so
Do you have another one ready for me?
Yes, Your Honor, it's in dismissal. Parental.
Cheryl Yvonne Carlton, 26R260085.
Good morning, Your Honor. Peter Bernal, P78413, MIDC counsel for this crime.
Good morning, ma'am. Your name?
Morning, Cheryl Van Carlson.
So you're gonna make sure that child gets to school. Because we know, and you know, and I know, and anybody else knows, they have no chance of succeeding if they don't get a diploma, right? Prosecutor moves to dismiss. It looks like things have gotten a lot better. Case dismissed. Make sure you get that child to school. Thank.
Yes, Your Honor.
Yes, Your Honor. First off, with regard to case number 42112, does the defendant wish to have a hearing, or does she wish to admit to the violation? At this time, she would admit to the violation, Your Honor. All right, Ms. Strickland, on that case that you were on supervision for, you understand you're entitled to have a hearing? You are entitled to have a hearing. You wish to waive that hearing and admit to the violation? All right. Court's going to find that you have violated the terms of your community control under case number 42112. Anything else, Mr. Goodyear, on the sentencing case?
Your Honor, regarding sentencing, I know that, first of all, I would note that the victim's representative is present today in court. She spoke to you the last time, so she does not wish to speak again, but she is present.
Which case? Is that
On the new case.
That was one of the victims, right?
It was
multiple victims.
Correct. So we have 3 businesses that were victims because the checks were cashed at their location, but the checks were stolen from a gentleman who's passed away, and this is his daughter that is here in court today. And like I said, she spoke to you last time as well. So, Judge, you want me to speak to sentencing on both cases?
Yes.
Okay. So I know you've had a chance to, you're well aware of Ms. Strickland's record. It is not an exaggeration to say she's a lifelong thief. She is someone who, frankly, has taken advantage of people and relationships to her benefit and only her benefit for many, many years. And then on top of that, as we've discussed in chambers and in this courtroom previously, she then perpetrates a fraud on this court, claiming that she has cancer and used that false diagnosis to her benefit a number of times regarding this case. And so I think that Ms. Strickland has shown that she is never going to change, and the only option for her is to be sent to prison so she can not be out of in the community harming other people. So the state would ask the court to impose a prison sentence in this case. I think that would be the appropriate outcome.
Anything from probation?
Nothing in addition to what was discussed in chambers.
Anything on behalf of the defendant? Your Honor, at this time, Ms. Strickland has provided a restitution amount to my office, which has been placed in a trust account, and my office has written a check for the Warren County Clerk of Courts for the amount of $4,000 for her restitution. I also have a certificate of completion. I had several certificates of completion for 30 hours of completed online alcohol and drug education for A New Direction. I believe also Ms. Strickland has provided me with medical documentation where she has been present with and met with a pain clinic several times over the last 2 years for pain management. I would just at this time request a minimum sentence. Ms. Strickland, is there anything you'd like to say? Is there anything you would like to say?
I'm sorry for everything I've done, past and future.
I'm sorry?
I'm sorry for the stuff I've done from the past and future, and I'm reaching out for help.
Ms. Strickland, you started your criminal offenses back in 1990 down in Kentucky, right?
Yes.
1990, this is 2026. That's 36 years of you stealing from people. Have you ever had something stolen from you?
Yes.
Not a good feeling, is it?
It's bad.
Especially when you steal from people that are your family, friends, and people that have placed trust in you. And you turn around and steal from them. Horrible feeling. It really causes people to just distrust their neighbor more and more. This is pretty disgusting. And quite frankly, you did this last one with the stealing the checks and stuff. I guess it happened just before I sentenced you. So while you're awaiting sentencing on this one felony theft case, you go and do it again to multiple people. It's pretty aggravating. So
At this time, the court is going to find that you are, I've considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. The court is going to find today that you are not amenable to community control and that prison is necessary to fulfill the purposes and principles of sentencing, including punishment, deterrence, and protection of the public. Probation would certainly not adequately punish you and would demean what's happened in this case throughout your history. The other thing I want to mention is not only you steal from people, but you lie to people. You make up this whole thing about this cancer and you're dying and you're trying to gain sympathy from people. And apparently it works because people fall for it. But your extensive criminal history, you haven't responded to previous sanctions. And this last opportunity, you went out and you just did it again. And I think you'll continue to steal from people because that's just who you are. So, gotta make sure I get this right. Under case number 42112, the court is going to order you to serve 9 months in prison. Under case number 42654, the court is going to order you to serve 12 months in prison on count 1, and then 12 months in prison on the remaining 3 counts of forgery. The 12 months on and I don't know, the count numbers are 3, 5, and 7, I believe.
That's correct, Judge.
Those will all be served concurrent with count 1. But count 1 will be served consecutive to your sentence in case number 42112. The court does find a consecutive sentence is necessary to punish you and to protect the public. It is not disproportionate to the conduct or the danger that you pose to them. And your criminal history demonstrates that a consecutive sentence is necessary to protect the public. You are also subject to a discretionary period of post-release control, which means when you are released, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time you get sentenced to. What's a jail time credit?
137 days, Judge.
137 days, all of that applied to case number 42112. Other than that, the court finds that you're indigent for the purpose of any fines, costs, or financial sanctions. The court will accept the restitution payment today that you have paid on that. And I think that's all on count on the first case, right?
I'm sorry?
That's all on the first case?
The restitution amount?
Or is that all of it?
It's for both.
Okay. All right. So there will be no restitution ordered at this time. There may be opportunities for you to receive up to 1 day per month for participating in certain programs sponsored by the Department of Corrections. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. Mr. Goodyear, is there anything else?
No, Your Honor. Thank you.
Anything else?
No, Your Honor.
All right. Thank you. Justin, take it. Thank you. This is case number 24CR41964, for the State of Ohio versus Tawana Collins. Ms. Collins is before the court with her counsel, Mr. McKenna, Ms. Tranter, on behalf of the State of Ohio. Mr. McKenna, does your client wish to have a hearing on this?
She does not. We have probable cause and admit the violation.
Ms. Collins, you understand on the probation violation that you are entitled to have a hearing?
Yes, sir.
You wish to waive that hearing and admit to the violation?
Yes, sir.
All right, the court's going to find that you have violated the terms of your community control. Despite this violation, the court's going to find that you are still amenable to community control, so I'm going to continue you on community control at this time. I'm going to order a new mental health assessment, and you're ordered to comply with the recommendations of the assessment. The court is going to order you to complete successfully the STAR program with any recommended aftercare. Once you've completed that program, you'll be placed on electronically monitored house arrest for a period of 90 days. Looks like you have 64 days jail time credits. That sound about right?
Yes, sir.
All right. Anything else, Ms. Tranter?
No, Your Honor.
Mr. McKenna? All right. Good luck to you, Ms. Conlon.
Thank you.
Mr. Cox? This is case number 25CR42737, the State of Ohio versus Eric Cox. Mr. Cox is before the court with his counsel, Mr. Perry, Ms. Tranter, on behalf of the State of Ohio. We are here on the defendant's motion for judicial release. Does the state have a position?
No, Your Honor, we'll defer.
Anything from probation?
Nothing further, Your Honor.
Mr. Perry, you wish to be heard.
Judge, we would submit on our previously filed pleadings and prior arguments.
All right. Mr. Cox, is there anything you want me to know?
Just that I'm sorry. I'm very sorry that I'm here for my behavior that led to this. I'm grateful for the opportunity to come back and for you to consider the motion of judicial release. I just want you to know that I am super determined to never let anything like this happen again. I don't want to let my mom down. I don't want to let my fiance down. I've got a business on the line. Like, this has been a nightmare. I've learned from it a lot, and I've learned a lot about myself. I guess one good thing is the diagnosis of bipolar to describe and explain what's been unexplainable. I take that very serious and being compliant with my medication and just making sure that I have a stable platform where I can work a program of recovery, where I can make my faith a priority, where I can live a productive, good life and not have to put myself in a situation like this again or others in harm. That's it, Your Honor.
Okay. All right, Mr. Cox, I do remember vividly when I sentenced you, and I did tell you that I would consider judicial release. So at this time, I'm going to honor that and indicate that I'm going to suspend further execution of the prison sentence and grant your motion, place you into community control for a period of 3 years. Now, you'll be subject to the supervision of the Warren County Probation Department. You're ordered to refrain from the use of any drugs, alcohol, or marijuana. Do you understand that?
Yes, sir.
Okay. Now, I'm going to order an updated assessment because the assessment that we have is back in November of 2025. Since you've hopefully been abstinent over the past 6 months.
Yes, Your Honor.
I'll assume that you have.
I have.
I'm going to update the assessment, including that mental health component. You are ordered to comply with that, any recommendations from that assessment. You'll be placed on a TAD monitor when you are released from the jail. You're not going to get released today. I apologize, folks, but I want to get this assessment completed because it'll be done fairly quickly, a day or so. Okay, is that right, Officer?
Yes, Your Honor.
Okay, thank you. As previously, would you give me an updated jail and prison time credit for me?
Prison time credit is 170 days. Jail time credit is 13.
All right, so sound about right? Who's counting, right?
Yeah. Yeah.
All right, so we'll update those for your record. Remember, your operator's license is currently suspended for your lifetime, so you have no driving privileges. Do you understand that?
Yes, Your Honor.
All right. There was previously a mandatory fine of $1,350, which I do not have the authority to waive. So that, again, will have to be paid to the bureau, to the court. Let's see. I'm also going to place you on a TAD monitor. It is an alcohol monitor. And I'm going to leave that. Did you say, Abby, you were?
He would go to Officer Sukavecki.
Sukavecki. So I'm leaving that to her discretion for how long that stays on. Generally, once you get settled in and she can see that you're engaging in treatment, I will leave that to her discretion. Okay. Ms. Tranter, is there anything else I left out?
No, sir. Thank you.
Mr. Perry?
Nothing, Judge. Thank you.
All right, Mr. Cox, let's get this right. Okay, sir?
Okay, thank you.
Good luck to you. case number 24CR42067, the state of Ohio versus Isla Garrison. Ms. Garrison is before the court with her counsel, Ms. Shy. Ms. Tranter, on behalf of the state of Ohio, we're here for a final probation violation hearing. And Ms. Garrison, I was able to obtain a copy of the indictment from Ross County, and apparently that conduct, which formed the basis for that conviction, predated this, you being placed on community control. I think everybody agrees with that now, correct?
Yes, sir.
So we're going to amend the violation to be what?
Your Honor, we will amend it to the defendant did violate rule number 8, in which the defendant failed to notify her officer of law enforcement contact with Ross County, Ohio.
All right. And Ms. Shy, and you want to reset this for a hearing, or do you just accept that amendment and we proceed today?
Yes, Your Honor, we're going to accept the amendment, and she's going to accept responsibility for violating rule number 8.
Okay. Now the big question, Ms. Garrison, comes in, and I spoke with Ms. Shy about this in chambers. It was my intention, basically, just to send you to prison for 9 months. That's the least amount that I can do, and that to be served concurrent with the sentence that you received from Ross County. Is that what you wants to do?
Yes, Your Honor.
All right. And again, I think your expected out date right now is December, right? So this is going to add a couple months onto that. The other option is that I continue you on community control. They send you to prison. I just mark that you're unavailable for supervision. And then when you get out, you're right back here in front of me. So I don't know that that's really the best use of all of this. Do you agree?
I agree.
Okay. So what I'm going to do then, let me pull this up real quick just to make sure I get this correct. All right, so on count 1, the court is going to order you to serve 9 months in prison. And on count 3, 9 months in prison, concurrent with count 1, and that sentence to be concurrent or at the same time as your Ross County sentence. Do you understand? On this case, you have 7 days jail time credit, and the court finds that you're indigent for the purposes of any fines, costs, or other financial sanctions. The court is now going to find that you're indigent for the purposes of any fines, costs, or other financial sanctions, and that includes the reimbursement to the state patrol. Now, on these cases, you are also subject to a discretionary period of post-release control, and same as Ross County. So when you're released, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, the adult parole authority, can return you to prison for up to 1/2 of your sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Do you have any questions for me?
No, Your Honor.
Ms. Tranter, is there anything else?
Judge, the only thing is her sentencing entry is reflecting she was only convicted on count 1.
Oh, I'm
So
sorry.
I'm not sure what you're looking at, but
Well, I'm looking at my notes that are obviously wrong.
let me.
Okay, well, forget the 9 months on count 3. So just 9 months in prison. Oops. 9 months in prison concurrent with Ross County. Okay. Anything else, Ms. Tranter?
No, sir. Thank you.
Ms. Shy, is there anything else?
We'd ask that the costs and fines be waived.
Yeah, I found her indigent, so that's
Okay.
okay. Good luck
Thank
to you.
you.
Something
Thank
is
you,
wrong.
Your Honor.
Hey, hold on. Something is not right. No, you know what, Judge, you're right. Before she goes. Yeah, I said that. You're right.
I was right?
What, you are right.
Yeah, there's 2 on the PSI.
Yeah, so I'm looking at this and it looks like Mr. Chester did a plea form for count 1 and count 3, but the sentencing entry only reflected count 1. I'm not sure how that slipped through.
All right. So we're gonna do a sentencing entry non pro tunc to reflect the actual sentence.
Yes.
Okay, and then just clear it up that way.
Okay.
And
And then we'll go back to your original sentence.
my previous decision will stand. 9 months on count 1, 9 months on count 3, concurrent, both to be served concurrent with Ross County. Make sense? All right, so I was right. Huh?
You were right.
There's a shock.
Did you get that down, Dina?
Dana, make sure that's on the record there.
All right, Mr. Williams?
These are case numbers 24CR41850, 25CR42462. The State of Ohio versus Aaron Williams. Mr. Williams is before the court with his counsel, Mr. Moss. Ms. Tranter, on behalf of the State of Ohio. Mr. Moss, we're here for a final probation violation hearing. Does your client wish to have a hearing?
No, Your Honor.
Mr. Williams, you understand you are entitled to have a hearing, sir?
Yes, I am.
You wish to waive that hearing and admit to this violation?
I do, sir.
All right, at this time, Mr. Williams, despite this violation, the court is going to continue you on community control. Court is going to order a updated assessment. Once that assessment is completed, you will be released from the Warren County Jail on electronic monitor with a curfew for 90 days. You're ordered to successfully complete the thinking for change course. Now, when we get this assessment, you are ordered to comply with all of the recommendations in that assessment. Do you understand?
Yes, sir.
Judge, probation is indicating that he received an updated assessment this morning.
Oh, there we go.
So
We talked about this on Tuesday, didn't we?
Correct.
Okay. What does it say?
Intensive outpatient is what DeCoach recommended.
Okay, so let's release him today on a monitor, on a curfew, and you got to get engaged in this right away.
I will.
All right. We have, what's the jail time credit?
66.
66 days jail time credit as of today. All right.
Correct. And you want curfew, do you want a term or officer discretion?
90 days.
90, thank you.
Yeah. Anything else, Mr. Moss?
No, Your Honor, but I think he has a question about.
With just employment, will I be able to work with the?
Yeah, that's why I put you on a curfew instead of house arrest.
Okay. Well, I just didn't because I know there's a time frame to be in and out. Maybe if I had to work.
Well, you can talk to your community corrections officer about that, the person that puts the monitor on you.
Fair enough.
And you can talk to them about your work schedule and stuff. Are we talking about verified employment or are we talking about under the table?
Verified.
Okay. Because if you're going to work, you're going to pay taxes.
Yes, sir.
Like everybody else.
Oh, yeah.
All right, Ms. Tranter, is there anything else?
No, sir, thank you.
Mr. Moss?
No, Your Honor, thank you.
All right, good luck, Mr. Williams. Let's get this right, okay, sir?
I will. Thank you, sir. Thank you.